It is a lot. Item 18 of today's daily list. Inform the private respondents that I have to file one impediment application. 2 weeks time may be allowed.
Okay. Mr. Ganguly, Learning Council, paying for the fee. As paid for, granted with time to file additional thing. Submitted that you have informed the other side.
Yes, I have informed.
For example, from the Learning Council for the other side. Please take it up.
Tablet.
In item number 41, I have filed an affidavit of opposition.
40,
41 yellow.
1.
Lordship. I have filed a affidavit in opposition on 9th of Lordship. It is not take with the record. Okay.
With consent of the respondents, my lord, may I be permitted to mention item number 26 of your lordship, please?
26.
26, my.
Yes.
We'll file a reply today in the course of the day, my lord. I was saying anytime may be picked for hearing of the matter. We have
After
already-
1 week, you have informed the other side.
We have taken consent.
Mr.
Vishwanath Chatterjee, my lord.
P. Chatterjee, Learning Council. For the petitioner has submitted that affidavit in reply.
Affidavit in reply.
Okay. On behalf of the petitioner, will be filed during the course of the day. He has just submitted that he has been posted after a week with the same affidavit in reply on record. It is further submitted by him.
But there is an interim order, my lord, may it continue.
Yes, accordingly, the interim order will continue.
Meet, please, your lordship.
1 week, my lord, may I seek indulgence of 2 weeks, my lord?
2 weeks.
I'm extreme doubt.
Meet, please, your
my-
lordship. Lordship, with the consent from the
Sorry, my lord, I'm one indulgence, man. May a date be fixed because I'm not from local from here, my lord. That is. I'm sorry to trouble you. Lord. I'm extreme doubt, right?
Meet, please, your lordship. Lordship, with the consent from the petitioner, I beg to mention item number 35, lordship. Lordship will be filing an affidavit in opposition. Lordship, may this matter be listed on 17th.
Would not prevent you after a week. Mr.
A. Ghoshal on behalf of M. Bishwas.
Mr. A. Ghoshal, Learning Council, appearing for M. Bishwas, Learning Council for 7, 8, 9. Yes, wait for. How much time you're filing? Today
Yes,
or what?
lordship, we'll be filing.
Today or what? Yes, wait for is granted for the time file between position on behalf of the data. It is submitted with complaint taken from the Learning Council for other side to the applicant. It is the case already after.
May I please, your lordship. Lordship, I beg from listing of land compensation matter, your lordship, for admission. Any day this week, your lordship.
Not this week. We have already fixed many matters.
Your lordship, with the consent of other side, I beg to mention item number 33.
Item number
Item number 33.
43.
33.
33.
That's right.
Yes.
In this case, we have received para-wise comment. Therefore, we need 3 weeks time to file affidavit.
Who is for the petitioner? Mr. A. Bhattacharya, Learning Council, has appeared on behalf of Mr. G. Rahul, Learning Council for the petitioner. MS,
K. Deka on behalf of our Mrs. R.D.
MS K. Deka, Learning Council, MS RDP, Central Government Council, has paid for and granted free time file. Counter is the case after.
May I please, your lordship? I beg to mention for listing of a case. Earlier 2 times the case was listed, but earlier 2 times case was listed but not reached.
Okay, next week with it.
Obliged.
Then what
please.
column? Bench 4 or bench 5?
Then 5.
What is the subject matter?
Land illegally occupied by the Power Grid Corporation.
Wait, Mr. Lordship, I beg to mention listing of petition regarding the arbitration petition.
Regarding?
Matter. Yes,
Regarding?
it's arbitration matter 2020
Okay. Next week, hello.
on 15th
Of which year?
2024.
Next week.
Obliged.
May I please, your lordship. I beg to mention item number 28.
28.
8, madam. 2 weeks time may be granted to file our affidavit in reply.
Okay, Mr.
HK Sharma.
H.K. Sharma.
My lord.
Okay, learned counsel for the petitioner has paid for and is granted 2 weeks time to file affidavit in reply on behalf of the petitioner. It is
Much.
submitted that you have informed us that
Yes, madam.
counsel has been taken from the land standing counsel NHM to make that way. Is the case accordingly after. Please, Petitioner,
May it please, your lordship.
let it be read out.
Your lordship, with the consent of the arrested, I beg to mention item number 23
23.
for adjournment.
You are for which?
Respondent number 8,
Respond number 8. Who is respond number 8?
JMB.
8 and 9 are the product minister.
Okay. Yes, sir. Mr.
HK Sharma.
H.K. Sharma, current counsel for the
Petition.
petitioner present. 8 and 9. 8. You are for 8.
Yes, lordship.
Eight means 9 also.
Yes,
Is it
eight
not?
with-
Yes, madam. 8 and
8 and 9.
Okay. Mr.
Jelotha. Jamilotha.
J. Lotha,
Yes, lord.
current counsel for the respond number 8 and 9. How much time?
3 weeks time.
Just wait for any granted. Please time to file a petition on behalf. Between opposition on behalf of the respondents. Please the case after 3 weeks continue with the office. The interim order pass the case will continue till the next.
Right.
May it please your lordship. May it please your lordship. Lordship, I beg to mention for listing of a writ petition. Lordship,
Motion.
for motion, lordship. May it come up on Wednesday. There are 3 matters pertaining to application of force measure.
Hmm.
GST service tax matter, lordship. May
Force
it
measure.
come up on Wednesday,
Friday?
Friday.
Yes, madam.
Not mandatory pass over for the time being.
Who is your senior?
It's a Saturday.
Art. Okay, Mr.
Should I
Be
wait
there.
to sometime?
Sometime. After some time.
Upright.
May I please your lordship. Matter is a contempt matter, your lordship.
Hmm.
Non-compliant.
Is your order?
The direction was given to produce certified copy of the
Forcefully speak.
order along with the
To the
deed
waited to
record.
enable the Who is the deputy commissioner, district commissioner, Kamrup? Why you are impleading so many people? They are not, they were not given direction. Only the district commissioner, Kamrup Metro has been given the direction.
Sumit Chakrabarti.
Third MS
R.
R. Dotto. Will only issue notice to the respond number 4. Others were not directed. Why you have roped in? Present contempt. Yes. File. Alleging. Non-compliant of the direct. Made. In. An order. Dated. (15/5/2020). Fasting. You know, 15 18 orders date 9/1/2000 and 15/5/2023 fasting. Period petition WPC number 304/2006 and contempt case number 239 to 2020. Respect. It is averted. A copy of the order duly submitted before the response of a having regard the direction in the order dated 9/1/2015 and 15/5/2015 comma notice comma at this stage is issued to the response number 4. So the notice is made returnable in 4 weeks. The petitioner shall take for service of notice of the response number 4 by return to Yes, I am sleeping. Okay. Heard Mr. Heard the petition in person. NMS RDB. Learned Central Government Council. For all the respondents. Presentation is before seeking appointment of an independent arbitrator under 11 independently of the arbitrator. As MSDB and Central Government Council has appeared the instance of formality is dispensed with. The petition in person shall have a furnished requisite number of extra copies of the petition to MSDB within 0. You furnish extra copies.
Okay, okay. So you will give me some specific dates, sir, in
Huh?
last week of May. Specific date. Specific date, sir. Will be better.
Specific date.
It will be
I
better for me.
And also one thing, the entire agreement is not annexed here.
Why part?
Only 11 portions have been annexed.
Why part? Why you are so miserly? Why you are so miserly?
And sir, it will be better for me for specific date because we used to
No,
go to
no,
site.
you have not annexed only that arbitration clause. That is what she is objecting.
Your Lordship, we are supposed to deposit the contract after completion of the work. That is
No, no, you have not annexed the contract agreement with your entire contract agreement.
We don't have, sir. We have deposit in the department after completion of the period and before payment of final bill. We are supposed to deposit in the department as classified document.
You don't have the
Yeah,
arbitration.
we don't have. They can.
Let us
department
record.
have-
Mr. The petition in person has submitted that he has not been supplied with the entire contract agreement.
12 reasons.
Notice to return for adequate number.
May please, Your Lordship, the instruction of third for Lordship.
Lordship, the instruction was received yesterday, Your Lordship. The copy mark to me.
the process of appointment of the member of the Assam Board of Revenue is under process, Your Lordship. The earlier advertisement had a criteria of 25 years of field experience, Your Lordship. That has been reduced to 10 years now. And as per my telephonic instruction, that has been reduced to 10 years. And the process is underway, Your Lordship.
Yes, what do you say about this?
Lordship, if they are going to Lordship appoint a division bench.
Earlier 25 years judicial experience,
Yes.
now there has been curtailed. Now it will be
10 years, if it is 10
10
years.
years as told me by the party.
process is on. Now when the advertisement is likely to take place.
Yes.
MS Boldre, any idea?
Lordship, it would take at least a month's time because now after the voting and all the model product is still on it.
Yes, Mr. Kulda, what is that?
Lordship, may fix after 3 weeks or 4 weeks, fixing a date. In the meantime, Lordship, if they appoint the next date, Lordship, I will do it.
Mutation is before division, man.
Lordship, they have Lordship referred a matter. Earlier, Lordship, initially it was in single
No.
bench. Subsequently, it's been referred to division. On first 2 days, Lordship, I was there. It was in before single bench.
Mutation appeal is under what provision? This appeal is again passed by whom?
Passed by the
Original order is passed by whom?
passed by the additional deputy commissioner.
Hmm?
Additional deputy commissioner.
Where is the order?
Lordship, at
The
Yes.
appeal under section 147B of the Assam
Eight.
Land and Revenue Act. 147B.
147B is the Lordship before the deputy commissioner, not the revenue.
That is an appellate order.
Yes.
Appellate order.
That is an appellate order.
Yes, yes.
Earlier, first order passed by circle officer, it was appealed.
Okay, then it is division.
Board of Revenue, it is
Then it is division. Appeal against the appellate order is division. Heard Mr. J. Colita, author for the petitioner, and Board of Standing Council Revenue and Disaster Management Department. Order. Response number 1. Para MS. Board of Standing Council Revenue and Department. Disaster Management Department. Instruct. Using instruct. As contained in a communication. of the Revenue and Disaster Management Department. I have submitted that process of appointment of member in the Assam Board of Revenue is under process. Earlier, and advertisement was issued for election and appointment of members. Laying down a criteria of 25 years of judicial experience. But the said advertisement has been withdrawn, has since been withdrawn. So the matter has thereafter been placed before the search committee, and the process of seeking approval for publication of a press advertisement for filling up the vacant post of member in the Assam Board of Revenue is in progress. So, MS Board has submitted that the case be lifted after 4 weeks to enable her to obtain up-to-date instructions as regards the process of selection and appointment of the member in the Assam Board of Revenue. Will you notice then?
Lordship,
Or should I file an affidavit regarding this instruction?
No purpose will be served.
yes, Lordship.
You give finality to the process, okay?
Yes.
Issue notice returnable on so and so.
Tenth.
The petitioner as MS Board standing out the revenue and appear and accepted notice on behalf of the respondent 1 and 3.
1 and
1 year,
Register
3 also. Yes.
no format, huh? No format. Extra copies. The petitioner shall be extended for
Right.
service after
Right.
1 or 2 registered
Right.
both within 0.
Lord.
On an exit fix, MS Board shall endeavor to make place further instructions as regards the matter of selection and appointment of the member in the Assam Board of
May it please your lordship. Lordship, the petitioner before your lordship is a power supply generator provider, my lord, who was entrusted with the work of providing power supply to the respondent bank. My lord, the petitioner have borrowed a loan amount of 16 lakh from the respondent bank, out of which, my lord, he has already paid and my lord, outstanding amount 3,36,521 is still pending, is yet to be paid by the petitioner, my lord. And my lord, by impugn notice, my lord, Annexure E page 17. Annexure E page 17. My lord. The respondents have, without giving any, my lord, notice to the petitioner, my lord, any information. to
What
the
kind of
petitioner.
public element is here? What kind of public
Lord,
element?
There was an agreement between the
No,
bank
what
and the
kind of public element? There is an agreement between you to supply a diesel set,
Yes.
right? At the bank premise.
Yes.
That
And
is
the-
one.
Yes.
Second is you took loan to install the generation. What kind of public law element is available here?
my lord, as per an
What kind of public element? A bank branch and the petitioner, Jamini Kumar Kanta Basumata. They have entered into some arrangement, one with regard to installation of generator set in the bank premise. Second, he took loan to install that DGLC.
Yes.
Right? What kind of public element?
My lord, the thing is that, my lord, he
So make
borrowed.
submission
Yes.
within the ambit and scope of 220.
My lord, there was an agreement between the petitioner and the respondent bank
Is it a
to
public?
deduct, to
No.
deduct the EMI of the loan amount from the rent of the services provided to the respondent bank, my lord.
Firstly, don't join this. Firstly, you took loan for purpose of earning your livelihood or whatever. That is one. And you supplied on generator set. Bank. What kind of public?
My lord, kindly peruse
No, perusal will not.
Annexure A, my lord. As per an office note dated so and so, my lord. He was,
No,
my lord,
please
entrusted with.
enlighten me. Please enlighten me on the ambit and contours of
Yes, my lord.
226. Whether this is whether this arrangement between you and the bank branch has any public law element. It has a private.
There is a dispute between the bank and the petitioner.
So is it before any other forum? Yes.
Purely private contract. This is the case of if he's at, even if his entire case is correct, this is breach of contract.
You don't find any. You took loan. There is outstanding. That is one part. You supplied it. He said
But
they
they
cancel
stopped.
the arrangement.
Yes.
Both are private. What public doing? If petitions are entertained as regards this kind of debt or 140 crore population, there are other forums set up. We don't find any. It is up to you. Hard. Will not entertain. Hard. Name please.
S. Upadhyay, my lord.
S.
Upadhyay.
Upai. Learning Council Product. A gang. Learning Council for the respondent.
1, 2, 3 minutes.
Punjab National Bank for the for number 1
and 3.
The case of the projected case of the pursuant to an stated by an official the respondent bank approved installation of 15 kVA installation of a 15 kVA generator set at Gopur branch of the respondent Punjab National or what?
Yes, my lord.
Earlier it was United Bank.
Punjab National Bank in bracket outside United Bank of India. For the purpose of uninterrupted power supply to the state branch. Also, the petitioner had obtained MSME loan for the purchase of silent 15 kVA gauge three-phase diesel generator set costing 3,63,000 from the respondent bank on 22/5/2000. So, as part of state financial facility, petition was required to pay equated monthly installments for 60 months. So, thereafter, an agreement was executed between the petitioner and the respondent bank authority. For the purpose of, as regards the installation of the diesel generator set at Kohpur branch of the respondent bank. So the state agreement. Agreements to capital. As far as state agreement, the petitioner was to be paid a monthly rate of rupees 18,000 including fuel and operational charges, subject to the conditions mentioned here. The grievance of the petitioner is that the petitioner, it is the case of the petitioner that the petitioner used to repay the EMI from the monthly rent received by him from installation of the diesel generator set at the Kohpur branch of the respondent bank. The grievance of the petitioner of the during the subsequent. The grievance of the petitioner is that on 21/2024, the respondent bank has served a notice for cancellation of the generator service facility provided by the petitioner at the Kohpur branch of the respondent bank. The petitioner has been informed that the generator service would be discontinued from 1/5/2000. After service of the state notice for cancellation, the petitioner submitted a representation before the branch manager, of the respondent bank at Kohpur branch on 4/3/2020. With a prayer to resume the generator service facility at the Kohpur branch. It is the further case of the petition that in view of cancellation of the generator service facility, the petitioner will not be able to repay the amount of rupees 3,36,000, which has remained outstanding against the loan he had obtained from the respondent 2014, you took 3 lakh. As on date, after 10 years, 3 lakh 36,000.
No, my
What
lord.
kind of service?
Loan
This is
amount
your
was
case.
16 lakh.
Huh?
My lord will peruse the account statement, my lord, page 16. Loan amount was 16 lakh, my lord, out of which he has already
But
made an
generator set was costing 3,63,000 according to, and the loan amount applied 3 lakh. Page 13.
Subsequently, there is
Subsequently-
there is another sanction of
Yes,
2007.
Okay. এটা মাজত লিখি দিম। Subsequently, comma, petitioner was granted. Sorry, the loan limit was granted. Sorry, the borrowing limit was higher. From the jurisdiction of this court, jurisdiction under Article 226 of the Constitution of India is to be invoked in a case where there is presence of any public law element. Neither the execution of the agreement stroke affidavit entered into between the petition and the respondent bank for installation of generator service facility at the Gohapur branch of the respondent bank and its subsequent and cancellation of such facility, nor the extension of loan to the petitioner by the respondent bank and the petitioner's failure to repay the loan timely has any public law element for invoking the extraordinary and discretionary jurisdiction of this court under Article 226 of the Constitution. So in such a manner, this situation is now not maintainable and the same is accordingly.
deeply.
Yes, what is your grievance?
No, only to register a case, my lord.
Can approach properly.
What?
Approach
my lord,
properly.
That way they may,
Huh?
that way may be disposed of, my lord, to approach the authority. Because we have filed.
Just for observation, you know very well. This
yes,
kind of writ petition is to be thrown,
yes, I know, my lord. Only
is
their
to be
observation.
damned.
Yes.
Sounds right. Did you approach the superintendent of police?
No, that is the thing, only that we did not, my lord. Just,
No, thereafter. Thereafter, first 154.1, thereafter 154.3,
Well, yes,
then
of course,
thereafter
of course, madam.
36,
Yes, of course,
thereafter
madam.
156.3.
Since we have approached my file, this,
Ah.
we have to give the liberty, my liberty to approach those my authorities.
Heard Mr. B. Sinha, Direct Counsel for the petition. Yes, Mr. Goswami,
It approach law.
or it should be entertained.
No, no.
And Mr. N. Goswami, Learned Vinayagam for the response number 1. The projected case of the petitioner is that he is an owner of a flat hearing. Number 3 in the third floor of a multi-story apartment complex named Urbasa apartment, situated at Social Road 1 in 781. Subject. The subject has been rented out to the respondent number 5 by executing a deed of agreement dated 18/8/2020, and as part of the deed of agreement, common the respondent number 5 was obligated to pay a monthly rental of 18,000 besides other amounts like electricity charges. According to the petitioner, Commander Respondent number 5 failed to make payment of the monthly rent since December 2003, and also failed to submit requisition for the purpose of police verification. The petitioner tried to contact the respondent number 5 despite repeated attempts on the part of the petitioner to contact the respondent number 5. The petitioner was not able to contact the respondent number 5, and the respondent number 5 has continued to keep the subject flat under lock and key for a long period of time, suspecting that the respondent number 5 is engaged in unethical and immoral activity like it is in the subject that command petition stated file a first information report of the in charge on 13th. The petition has approached the court by instituting the certificate without given despite submission of the state affair of the charge. This has not yet reached the state. The petitioner has sought direction in nature to the respondent for it that the affair stated in it caused by him to put off the charge. This appointed but in the petition. It was the petitioner has not yet, after submission of the FIR 13/2020, the petitioner has not approached any other authority. The person has a demand that his FIR has not been registered by the state, his first remedy is to approach the superintendent of police under section 154 criminal procedure 1970 or other referred to in section 30, CR. If despite approaching the superintendent of police or the officer referred to in section 30, his grievance still persists, then he can approach the magistrate under section 156 in bracket 3, here, instead of rushing to the High Court by way of penalty or a petition under section 48 here. It has been observed in mathematics. It is true that alternative remedy is not an absolute part, but it is but it is available and there is an alternative in the High Court ordinary reason. In view of the fact that the petition not yet put the authorities under section 153 or under section 36 or under section 153 here, that is not entirely, preserving the limit to the authority as part the procedure laid down in section 154(3) and so for and so for 153 here.
All right.
Made
Synopsis corrected.
corrected. Actually, one synopsis not actually in prayer minute. There is one word is left was left.
Huh?
Petition number 1. Kindly see.
What is your case?
My
what
case
are
is when our
petitioner,
land has
devotee,
been acquired by the authority,
Subhas?
my lord.
Okay.
But Siraj bill not given to the petitioner 1.
Uh-huh.
And land bill not given to the petitioner 2 and 3 in equal share. One nothing. my lord.
So we have modernized color. नाम जारी Miyadi Patta.
Very much. Annexure 1 minute, kindly see Annexure 1 minute.
Union Repoti. Then
Rebuti Bala
Subhas.
Rai,
Where is Subhas?
Subhash, serial number 6 minute.
Subhas 9. Serial number 9.
9. 6
Ah.
and 9. 3 persons here.
And 6 also.
6 also. 6 and 9.
6.
Other persons are there, but they are equated.
Okay. Then what happened? This part of this land has been tag number, patta number
Those are Millard. I have mentioned here Millard.
716.
Patta
Patta number 105.
Patta number 105.
Ah, what happened to that?
Land
It was a process of land acquisition.
mile. Land acquisition
Ah.
and our
Where is your notice?
notice Millard, kindly see Annexure
PKG, আপনার জন্য
2.
Deputy Mohan. Deputy Mohan.
Millard. He is Millard.
18. Okay. 4 lane. National Highway.
Deputy is the name of my
3G.
husband, one husband.
জমা দিবলৈ কোৱা হ'ল 0.4968 বিঘা
Almost half bigger.
3,15,820. Then 13 lakh.
13 lakh 83,000. And then again Millard 21 lakh.
Then 21 lakh.
21 lakh 7,980.
So it appears 3G amount has been assessed.
Yes. But not in equal share. Land is same Millard. We are entitled to get the equal share. Millard.
Then what happened?
We have filed and say advocate notice Millard there Millard, but nothing. Till
To
date.
whom you have filed?
We have filed Millard before the district collector Millard.
What the district collector will do? He is not a competent authority.
He is not
He does not have any jurisdiction to touch.
competent authority, land acquisition authority.
Will be, I think, additional deputy commissioner.
Yes.
Page 18.
Yes, yes.
Page 18.
My yellow is right.
অতিরিক্ত উপায়ুক্ত উদিন প্যাকেট কালা
Competent authority for land acquisition.
he acts as a representative of the central government.
Yellow is right. Yes.
He is not additional deputy commissioner. He is competent authority land acquisition.
Yes.
He is for acting under the NH Act. It does not act under the
District government.
superintendence of district commissioner. So what deputy commissioner will do? You have sent the notice to a wrong person. And plus 3G, if the 3G is there, what is there? If 3G is already there, it will be TH3, is it not? No, not arbitrary. Here is not case of arbitrary. It is a case of apportionment.
Determination of amount payable as compensation.
MS Bora 3H. TH3, please, Mr. Goswami. I think you will be in contact with Kala. Read TH1, TH2, TH.
PH1. The amount determined under section 3 shall be
As per the notice, amount is determined already. Shall be deposited by the central government.
as may be laid down by rules made by the government.
With a competent authority. Before taking possession of the land. Then 2.
As soon as may be after the amount has been deposited under subsection 1, the competent authority shall on behalf of the central government pay the amount the personal person entitled
3.
where the person claims to be interested in the amount deposited under subsection 1, the competent authority shall determine the person in his opinion and the amount payable to each of them.
If thereafter some dispute, then he has to refer it to the district judge. Now we are at the stage perhaps 3, subsection 3. Can you take instruction? He has determined the share, okay. Or otherwise they will prefer an application.
Under TH4.
Amount
TH3 first. But If they are not satisfied, then they make an application, you send it to
Civil court.
district judge. But if they are satisfied, then why the litigation is required? Suppose 10 persons, 1 bigha land, 1 crore. Everybody is satisfied with 10 lakh.
10 lakh.
End of the matter. Why litigation? It will take 2-3 years. Can you take instruction? What is the stage, exact stage? But you have not preferred any application.
Actually, application was
How to
filed by-
exercise our jurisdiction?
application was filed by the wrong firm.
That fact is not available.
Only to the
Jurisdictional fact is not available for the Kala to act.
Well.
He has no application before him.
Kala was made a party in this case of Kumbh.
Merely picking, but
Not to him.
there is nothing on before him.
Yes.
What to
The
do?
problem is the deputy governor has sent
Why
out
the written? If the Kala has not anything in his
in his hand.
hand, how can he act?
But let notice or Miller
No, no. When nothing cause of action, no cause of action is there, why?
But equal share should be there. But
You
they
first
have given
approach.
someone
That is
3
why
lakhs, someone
To
15
expedite, I have asked Mr. Goswami. Otherwise, you will not proceed. When there is no cause of action, firstly, like that the previous case, you have to make an application before the proper authority. Then you could have come that yes, he has not acted. Right? You have not made any application before the proper authority.
Then
You have made the application somewhere else.
then
How can
Miller-
he act?
Then Miller, we will file application before the him Miller. That is
Mr. Goswami, you take the instruction first. If the money has been disbursed, then he has to make an application for referring it to the district. If money is gone already out of the account, get the instruction. Third, Mr. A. Rashid, Learned Counsel for the petitioners, and Ms. Revenue, P.R. Mohan, Standing Counsel, Revenue and Teachers. One.
I put two real
Ken Goswami, Junior Government, R. Bora, Counsel for the respondent number, Department of, everything is wrong. Everything is wrong. Mr. Rashid,
I don't
don't
Miller.
make, don't,
I found
does
the
not
address
make
in
the homework
no, I found the same address in their communication.
for the respondent of I. The three petition. Sorry, the petition number 1 is the wife of late wife of one late Deputy Mohan Roy. And the petitioner number 2 and the petition number 3 are sons of late Deputy Mohan Roy. It is a case of the petitioner that as per the records of right, the three petition shares from a plot of land, covered by tag number 71 and patta number 105, situated in Puda, but Motia Revenue, District, Valpara. Have devolved upon them as co-partner after the demise of dead Deputy Mohan Roy. So it is the case of the petitioner that a part of the subject has been acquired for the process of ordering of National Highway number 70 full stop, under the provisions of the National Highway Act 1956 full stop, by 3 notice, comma, dated all date, oh no, dated 12/1/2023, 15/3/2023, and 15 and dated 15/3/2023. Compensation amounts. The petitioner, the issued in the name of late Deputy Mohan Roy, comma, the competent authority land acquisition, that is the responsibility, had informed that compensation amount of rupees 3,50,820, comma, 13 lakh 83,186 and 21 lakh 7,980 have been determined for disbursement as against acquisition of the part of land which has been acquired out of the subject. It is a further case of the petition that the petition has not yet been disbursed their shares, their legitimate shares out of the compensation amounts, comma, assessed under section 3 of the and submit and appearing for the response of appearing for the response of 2, 3 or 4, 2, 3, 4 has submitted that he will obtain his fact as to whether the respondent of court has determined the persons entitled to receive the amount payable under section 3 of the underneath. Yes, sir.
22. Field shop actor.
Mr. Rochit Larnik of the petition shall furnish 2 copies of the deputy along with connector to Mr. Prasad for deputy obtain the above. Is the case on 22. Get the information.
The senior is in lab.
Your senior is Talukdar.
Yes.
Okay. Talukdar is important.
After some time.
Fine. Provide an order, no supervisor, discipline.
Yes. Order is a petition submitted.
Petitioner mediation application was rejected, lordship, but there is direction to bring that order, but we could not get.
Huh?
We could not receive, Lord.
Order have been rejected.
That order was supposed to produce today, Lord, but they could not receive, Lord.
It is available perhaps on your website.
Lordship, I would like to pray for filing an additional affidavit because the petitioner
Is it
has,
available in the website or not?
I have checked, but I
Huh?
couldn't find it.
Every process is step by step. Information is available in the website.
I have not gone through it,
Huh?
Lordship. For the website, I have not gone through it. I have
Because I have tested myself. The step by step progress of your application is shown in the website. But access to the website is very difficult. Traffic is large.
Lordship,
You should have,
the
if
petitioner
the
has
application is
received-
rejected, the order is uploaded.
I will go through it, Lordship. And I will file an additional affidavit because I've come to know today in the morning that the petitioner has filed an appeal because his
Appeal, then what more? See, madam, you are filing appeal there,
yes.
statutory appeal, and you are pursuing this.
No, he has filed an appeal before a DC.
Huh?
DC.
He is the appellate authority. Under the Right to Public Service Act, two parallel proceedings for the same cause of action.
We have come to know today in the morning. Lordship.
It is registered or not?
No.
Huh? Your client is more techno-savvy than you. Get the instruction as to why should we keep this pending if the appeal is registered already. We'll observe that appeal should be disposed of. That's all. Get the instruction. Appeal is registered, get a number. You have WhatsApp? Yes, madam.
Lordship, kindly peruse page number 53, annexes, annexes 17, Lordship.
17.
Page 53.
Page 50.
This is an order passed
Deepak
in,
Datta versus Chairman. You are Deepak Datta or Anup Datta?
Lordship, I am
Who is Deepak Datta?
Lordship, he is respondent number 8, Lordship.
Respond number 8.
Eight.
Okay.
He
Heard
has
the matter.
appealed against the order passed by the Silchar Municipal Court, Lordship, for demolition of illegal construction made by him. Lordship, page 54, Lordship.
Hmm. So, you, madam, you are appealing for municipal board? What you are doing? November 2023 order. Why you are waiting? That order has been passed in compliance of an order of this court passed in a writ petition.
For early disposal, Lordship.
By the 3 weeks that may be allowed to file our application.
Heard Miss
P. Sharma, Lordship.
P. Sharma, Learned Counsel for the petitioner. Yes, Mr. Goswami. 1 to 5. Mr. N. Goswami, Learned Junior Government Advocate. Some for that 1 to 5. MS S. Mutahari, Learned Training Counsel.
Lord, I am appearing on behalf of Mr. S. Datta.
Mr.
S. Datta.
S. Dr. Senior Counsel. MS Mutahari, Learned Counsel. On behalf of Mr. S. Dr. Learned Training Counsel. Silchar Municipal Department. For the response number 6 and 7. The petition is agreed by inaction on the part of the respondent authorities, more particularly, the Silchar Municipal Board Authority. In carrying out to execute the order dated 4/11/2022 within bracket, Annex 7, passed by the Chief Executive Officer. With him, Mr. Goswami, Kasar Jila Parishad, Municipal Board or Jila Parishad?
Executive Officer, Kasar.
Kasar Jila Parishad, what he has? He has no authority. Whether he has authority? I think this order appears to be void then. Appellate authority. See page 51. Paragraph 3. Learned Senior Counsel appearing on behalf of the petitioner submits that if the Additional Deputy Commissioner Kasar Silchar, that is the appellate authority, disposes of the appeal, right? I think Additional Deputy Commissioner is the appellate authority. And direction was made to the appellate authority to dispose of the appeal. Now come to page 53. It is completely different. It is not evident that he is also discharging the duties of additional deputy commissioner. Yes, can you
Lordship,
remove this kind of
senior-
confusion?
Let my senior appear. Lordship, and pass over the
Somebody has been directed to dispose of the appeal, Mr. Goswami, but somebody has disposed of the appeal. Whether he is the same authority. If he discharges both the functions, okay. Some wrong typing, some wrong letterhead. But he does not. Where should we go? Call both the senior counsel.
Lordship.
Right? Your senior is available?
Yes,
Your senior is available?
Please, your Lordship.
The documentation
Yes, please tell me. What is the story?
Lordship, story is that Lordship, although Lordship two notification under section 3A and Lordship 3A1 and Lordship 3D has been issued, and our patta number of our land is not also in the notification. So subsequently, Lordship, the concerned authority person Lordship has Lordship acquired our land.
Your patta or khatiyan?
Lordship,
Huh?
earlier
What is the difference between patta and khatiyan?
Earlier it was Khatiyan Lordship. Subsequently, it has been Lordship converted to Lordship Tiras Patta.
Where is that?
Yes, sir. Page Lordship 17.
17.
Yes. And 18 is the original Lordship the revenue.
17.
17 and 18 is the
18.
yes.
Haripara, Pokar, Dia. This is Khazna Road.
Khazna, yes.
This does not indicate anything.
And patta number 1 Lordship is there in the last. First is Lordship 223 515 207 then the 1. This
Which
land-
one? Which one? You are interested in which one?
One. Page number
1.
18. Yes.
Let us see more document as regards to 1.
More document Lordship is right now Lordship document only I have
Huh?
annexed the page 16.
Page 16. Let
Page
us
16
see.
Yes, page 16 Lordship is the Khatiyan and father of the Lordship petitioner name has been recorded at serial number 5. Janiram Das.
Father of the petition.
Such.
Rani Ramda.
Yes, serial number 5 Lordship will find in page number
Hukum
16.
Khorja Paru Uttarakhand Upen Kami Khanot. This is Khatiyan. Khatiyan. Suppose it is Katya.
Yeah.
Janiram Das.
Yeah.
Petitioner's father. Okay.
So lordship, they have acquired our land and also demolished
Where? Acquire your land.
in
Show me some.
in Dag number lordship 405.
Huh?
Dag number 405.
Old Dag,
land.
Old Dag, New Dag 405.
Yes.
Now you're showing me page 18. No 405.
Page 4, lordship page 18.
See, you have taken me to page 16.
Yes,
There are old Dag number and new Dag number is 405.
405.
Now you have taken me to page 18.
Page 18.
There is no Dag number 405 showing.
Pata number is there.
No, Pata number, nothing.
Pata number is there.
223.
Now it has the number is 1 lordship. Pata number 1.
Okay, let us take your submission. 1, Pata number 1.
Yes.
Then to me, 3A.
3A notification lordship I have annexed.
Where is that?
Their number,
Your
their name is not there. No,
Huh?
Pata number or Dag number is not in the 3A notification.
Not even P
Yeah.
in T.
In 3D also lordship not.
Not then.
Yeah.
Okay. Then
However, lordship,
what happened?
in November lordship, the person concerned lordship, they visited the area and measured the area, and the petitioner were asked to lordship demolish their residential house.
How? Show me document.
Lordship, document is not here. Lordship will find out. representation.
Measurement was carried out. The measurement does not mean that it has been acquired.
Lordship will see my representation. First page,
3A, 3D, your
Yeah.
land details are not there.
not there.
Somebody went there,
Yes.
carried out measurement.
Yeah.
Okay.
Lordship.
Then thereafter,
Thereafter, lordship, they have demolished page number 19. This is representation.
who had demolished?
This petitioner, because petitioner were
Petitioner herself
Yeah.
demolished.
Yes, lordship. Their own
Why?
on the instruction of the
Oh, for Bharwell.
Farwell lordship.
Today
Because
I'll
they have-
ask Mr. Kolita.
Lord,
Oh, you demolished
I
it.
could understand lordship's question.
Huh?
The thing is that lordship, since lordship construction is going on, and land of the prisoners fall within the lordship ambit of this four land, they were asked
How
to
can you know, right? Because 3A, 3D, your land was not there,
Yes.
right?
Okay.
Somebody visited, Mr. Borua visited,
That-
you
Yes. That
demolish this
notification
building.
was
Okay, I'll demolish this building. Then how this assessment is carried out?
Lordship thing is that lordship, after demolishing, they have come to know that already there was two notification and their name was not there. So that is why lordship, prior to getting the information that two notification was there, they have submitted a representation. Since lordship, we have
You are
demolished,
very devoted to the nation.
lordship will kindly let them lordship dispose of my representation. That much lordship I am praying that. If lordship,
If I don't find anything,
lordship,
any
page number
merit in
19
the representation, why should I direct?
lordship, otherwise,
This
lordship,
court is otherwise not very interested in disposal of representation business.
no, lordship thing is that lordship, since they have already acquired, and the land of this petitioner lordship fall within the ambit of four land,
Where is the evidence that
Evidence,
your
lordship.
construction is done?
construction is there, and also documents lordship, that we have demolished the construction house lordship, constructed house that have mentioned in my petition. Represent.
No, you have mentioned.
Yes.
But
If lordship,
you have mentioned you are yourself demolishing your own house without any instruction, without any semblance of any document.
if lordship
3A,
next week, lordship,
3A, it was not there.
not there.
3D, it was not there. Somebody visited yours, carried out measurement,
That-
right?
About
You demolish this.
Lord.
Okay, I demolish.
about the notification that they have learned subsequently. That is the problem, lordship. Lordship may take it on next week, lordship. I will instruct my client
Satisfied.
next week, lordship. If there is any evidence, lordship, I will reduce as a additional evidence, lordship. Like the photo and the construction, whether their construction is going on over the land of the petitioner, lordship.
Provide something tangible. Somebody at the instructor, Mr. Borua will
That is
demolish
the mistake
the
was
house.
committed by this
It is
petitioner, lordship.
not
On verbal instruction,
believable.
Yes.
You
Lordship, I
have
would-
annexed document. What?
in next,
Photograph.
lordship, after the
Photograph.
photograph, yes, they have mentioned the
Where?
photograph. They have photograph not here. I will lordship it is additional evidence.
I'll dismiss this.
No, lordship will take it next week, lordship. Whether I will take lordship proper instruction, whether lordship construction over the land is going on or not.
Mr. Kolita is a
Lordship-
seasoned lawyer. He should
Lordship-
know
Lordship, I
documents are required
Yes.
to be brought.
only lordship mistake. committed by
Demolishing
the-
a house
They have lordship plan about
on the prayer of
subsequently,
Mr.
lordship.
J. Kolita learned comfort of it. Mr. Any Mr. Borua, you appear for what? 6. Mr. S. Borua, land use number
or NHADCL
five, and Mr. T. Borua,
or 6.
representing of NHI
DTL.
Lordship. Next, the Lordship, I will try to oblige.
Lordship, the land of the petitioner was acquired in the widening the national highway, Lordship, and the value was assessed below. At that time on page number 26, Lordship, I submitted a representation for assessment of the tea factory and the building that has not been assessed. The page number 20,
Yes,
annexure
Mr.
4.
Borua. Where is Mr. Borua? T. Borua. Or you appear? Okay.
Then Lordship, page number 27, annexure 4, Lordship. Then the ADC, land acquisition, has directed the executive engineer for assessment of the tea factory value of acquisition for Netherlands of the petitioner. Lordship.
Assessment is going on for last 9 years.
No, Lordship. What happened? 2014, they pay some amount. Immediately, upon coming to know, we put an objection on 2015, Lordship. That application was entered in. 2014, the assessment was done. And 2015, we received the amount and immediately we put an objection on 2015, Lordship. Then, page number 27, ADC directed the executive engineer with reference to so-and-so, I am enclosing a petition submitted Janaki so-and-so Hendrik Borua Enterprise, Simalgura Tribute Revenue for assessment of tea factory and machinery value of acquisition for national level 37. Then, Lordship, these are my application. Then, Lordship, page number 29, kindly, Soma. 2015, what happened? Then, ADC give an intimation on 31st October 2015 regarding the assessment of tea factory. Below part, you are requested to assess the tea factory machinery by an approved or registered machinery surveyor, valuer, to get your compensation. Because my entire tea factory has been converted into scrap.
So how much you have valued?
Now, I've heard that my representation has not been considered till date. So many representations submitted, Lordship. Kindly.
No, you submitted valuation.
Yes,
There.
valuation reports, that was also
1
done.
crore 94 lakh.
1 crore 94 lakhs. Then, Lordship, kindly see that part
And
also.
what happened?
There,
You submitted the valuation report.
report. Then, after that, nothing was done by the
When did you submit that valuation report?
that is, I have submitted, Lordship, on 2/12/2015.
Now what
on
happened?
that-
It was acquired or not acquired?
No, acquired. Part of my building has been marked because tea factory was there. This is adjacent to national highway. Complete that. And attached tea factory that has been scrapped on the national highway while going to the TO on the last that Barua Tea Company that has been scrapped into. Nothing is worked there. So I submitted one after another. The finally representation was submitted again on this. They have accepted, but nothing is being replied to 24/3. Last page number 54, Lordship. Annexure 10. 14/12/2023, I again submitted a detailed representation.
Yes, sir.
They received. Nothing is replied.
10 years you are taking assessment for us.
No, ultimately, as per this letter 20, page 29. So petitioner have been asked to make the assessment and submit the report.
Submitted. Submitted.
It's submitted. And after this, what has transferred? Because ultimately this is a long.
Heard
duration
Mr. B. Sharma, like counterpart of meeting.
Yes, 5, 6, 7.
That direction is necessary.
Yes, which for one? 1, 2, 3, 4. Okay, Mr. D. Bora. Learning council preparing for NSR Bora. Learning council, NHI and NHID. For the response number 1 to 4. And Mr. S. Borua. Junior
5, 6, 7.
Response number 5, 6, and 7. The petition has proceeded. Agreement. the respondent authorities have not yet brought the process of the building and key factory, which have been explained already under the National Highways Act. Connect with National Highway number 39, comma, which logical conclusion by finally determining the amount of compensation. It should not be done as project as project as product. Extra copies within few of it. Meet with your lordship.
An illegal construction has been done by my neighbor, your lordship. An illegal construction has been done by my neighbor.
Neighbor.
His residence, your lordship. There are page 38, your lordship, may kindly peruse.
38?
8. May I read your? This was issued by the chief executive officer. Whereas notices were issued against construction of a commercial G+3-story building by Sri Manoj.
Yes, Mr.
But so far as my preliminary instruction is concerned, Lordship, subsequent to order date 13 to 2023, the building has been sealed on. Now they are complaining that since March 2024, they have again started construction. Lordship, I have to take instruction.
First you take instruction, then we'll proceed. Friday? Friday?
Yes, sir.
Okay. Third, Mr. Theory, Land Council for the petition, and Mr. P. Nayak, sending out DMD and DMC.
1, 2, and 3.
For transport number 1, 2. Yes. Request of Mr. Nayak. Let the case be listed on Friday to enable him to obtain further instruction in the matter. I don't know, to instruct in the. You need any copy?
Not I have copy.
You have copy?
Yeah.
Yes.
May it please your.
In this case, they have challenged, considering that this proceeding has not been initiated, although provision is there. But still, I may pray that matter may be taken on next Tuesday, the meantime I will obtain instruction. If there is any violation, correct it or keep that aside.
Okay.
Yes.
Monday. Then if required, we will decide.
Yes.
Okay. Mr. Okiwati, Land Council for the petitioner, and Mr. S.T. Kyle, Land Standing Council, Income Tax. For the respondents, all?
All right.
For all the, on the request of the is the case on Monday to enable him in instruction in the
May please. The petitioner here, Lordship, is aggrieved by an order, Lordship, passed by the Women's Cell, Lordship.
Women's Cell?
Yes. Lordship, what happened, Lordship? The one Niru Tao, Lordship, and she claimed maintenance for herself and her daughter before the court of the SDGM. That was dismissed because they as per law, they are not entitled. Then subsequently, they went for revision, Lordship, to the session judge. That was also dismissed. Then the daughter approached the Women's Cell, Lordship, and Women's Cell passed this impugned order.
Women's Cell, it is constituted under what? What provision of law? Any idea?
I had no idea, Lordship.
Where is the impugned order?
Impugn order is at page, Lordship will come to page 36, Lordship, that is the type of Lordship.
36. Yes, sir.
Yes, gone beyond. Jurisdiction.
Heard. Mr.
M. Hamid.
M. Ahmed. Sir, counsel for the petition. Mr. Bora, you would represent whom?
I'm not sure as regard whether the
Women and Child Development.
yes, that one, two.
2. 3 also. Assistant Commissioner.
member.
He is
He's
member of Women
al-
Cell, but
already
his
member.
main resignation is
ADC.
Assistant Commissioner.
Yes.
Junior Government Advocate for the reference number 120. The petitioner hearing has challenged an order dated 12/3/2024 passed by the respondent number 3 in his capacity as the Assistant Commissioner, Lakhimpur, and permanent member, Women's Cell, Lakhimpur. Whereby the respondent number 3 has directed the petitioner's employer, the Chief Workshop Manager, NF Railway, Mechanical Workshop, Dibrugarh, to deduct an amount of rupees 5,000 from the salary of the petitioner and to deposit the same in the account of the respondent number 5 as maintenance. 4 as maintenance. The said order is stated to have been passed in a case, case number 82559 24. Whereas it is the case of the petitioner that the respondent number 4 had earlier preferred an application under section 125 CRPC before the Court of London Subdivisional Judicial Magistrate within bracket M Kokwakana Company against the petition seeking maintenance. The state application was registered and numbered as case number 05 2009.
19.
2019.
19.
19. Seeking maintenance for her and her younger daughter, her daughter.
The petition of that maintenance petition was filed by the mother. Mother and seeking maintenance for this respondent number 4.
Respondent number 4 is daughter.
Daughter. But she is major.
By the mother of the respondent number 4 for herself seeking maintenance. Huh? By the respondent number 4. By the mother of the respondent number 4 seeking maintenance for herself and her daughter, that is the respondent number. On the ground that the marriage between the petitioner and the mother of the respondent number 4 was solemnized in 1999. The Court of London Subdivisional Judicial Magistrate M. Kokwakana decided the said application, case number 05/2009, on contest, by a final order dated 18/2020 whereby the claim for maintenance was dismissed. Full stop. When a criminal revision petition, criminal revision number 01 1 2003 was referred before the court of the additional session just in bracket not of against the final order dated 18/3/2020, the state criminal division petition was also dismissed by judgment and order dated 8/6/2023, thereby, affirmed, affirmed the order dated 18/3/2020. Issue notice regarding for which as suspense appeared 1 to 6 from application of case for services of the court by the in view of such facts obtained the case from as protected by the application, the impugn order dated 12/2020 passed by the respondent shall remain state until further orders. Prime, including prime, the does not here prime three has the authority and jurisdiction to pass an order of unit in view of the determination on the matter of appointment by the court of learning.
Yes. Maybe. But the page number 34 is the impugned order.
There are
page 34.
Yes.
Yes, my lord, 12 page is the petitioner and respondent number 7 and 8. That is joint owner of the.
It is based on a complaint by Aradhana.
Yes, based on the Aradhana Borua, she is a sister.
House number so it was with you. Asking you to approve drawing and note on the basis of which you have carried out the whereas you have failed to submit it. Where is 12/1/2024?
12.
Show cause notice.
Show cause notice, my lord. Page number 32.
Page 30. Horizontal extension of the ground floor of the existing old D+1 art building by constructing an Assam type house or group.
Assam. In actual NOC, there is a provision for that room. But the NOC was in the name of his mother.
Okay. Okay.
But then they call for the document. But they are saying that the NOC is not in his name. In IMP.
Okay.
And complaint was filed by his sister. Respondent number 5.
Basically on two grounds, that NOC was not in your name
In your
and the validity of NOC expired.
Validity expired. He cannot NOC has a particular validity. He has to extend it. Maximum is, I think, 7 years. After that, cannot. You have to take a new NOC. And in fact, my lord, if Lordship turns to page number 29, the petitioner himself has admitted that he has constructed staircases and he will remove it in 10 days.
No, but the staircase is in the part of the staircase is not part of the so-called notice. Staircase is not part of the so-called notice. Or huh?
There is a
It is some Assam type rule.
Assam type. Actually, my lord, he
vessel between all the
only 3 feet wide. Assam type room.
Now, where is your NOC? NOC in the name of your mother. Where is it? Next.
Not part of the record.
Part of the record.
Not part, huh?
No, I have not annexed the NOC.
Why?
In fact, he on notice he submitted to the JMDA.
So it appears that it is not totally illegal. It appears to be irregular.
Irregular.
That we have to.
No, I don't know. But
regularize, but
no,
it is not that constructed something.
No,
initially, my lord,
it is not without permission. Permission expired. NOC. NOC expired.
NOC.
And NOC was obtained by his mother.
But NOC, my lord, mother, but not enclosed in the petition, my lord. That we have NOC has not been part of the record now in the petition.
Right.
And furthermore, my lord, one thing, my lord, that particular page number 23, the final order.
Page
34, my lord, the final order of rejection. That as per the Act, under section 17, you have to go for an appeal. Because there is in the Act, there is statutory appeal provision is there for the district judge. And that option he has not exhausted. Because that order of the district judge is final. Because the Act says that you can go for an appeal and any order passed by the.
Do we have the notification? 74, huh? That I asked you earlier also.
I have the notice, I'm doing it more, but that today I'm not holding the notification.
Because I asked you to earlier also, where is the notification?
Where is the notification?
Because lots of writ petitions are filed. I wanted to have that notification. You are still not providing.
I will wait, I have it.
Don't take any question until Wednesday. Get it?
When not the notification.
We'll see your NOC also. Get the NOC also.
Next time case started, I have filed a representation to reconsider.
Representation will not do when there is a provision for appeal. When there is a provision for appeal, there is a provision for appeal before the district judge. You can prefer the appeal. He can go into all the facts and law.
And any order passed by district is final. That is
the. Nothing is final. Writ petition, jurisdiction or writ petition, it cannot be ousted. It is within the basic structure. But that appeal is there, then he can prefer appeal. Not 74. GMT
71.
71. You get the notification.
But I have it, I will get.
It will be easier for the court to dispose of many writ petitions in a proper case.
643. This is the book, well, page number 640.
I'm holding an old one.
Yes, there is a GMT. Old one also have the
GMDA 71.
71.
It says about appointment of an appellate authority.
The appellate authority has come
now.
Notification.
Oh, notification.
Because
I find I have found difficulty. Without anything.
I will place it, man. I have.
You place the NOC. Day after tomorrow.
Day after.
Third. Ikeda.
G. Patwa.
G. Pathak, learning counsel for the petition, and Mr. S. Bora, learning pending counsel. GMT and GMT.
Even all, here only your GMT.
GMT. For the response number 1, 2, 2, 2,
No, 1, my lord. 2, 3, 4, 5.
2, 3, 4. And S. Bora and Junior Government. 1 and 6. 1 and 6. 1 and 6. 1 and 6. Mr. Pathak, learning counsel for the petition, produce the NOC, copy of them, on the basis of which the law, which has been referred in a impine order dated 18/6/2024, Mr. Bora and sending up has submitted that the notification appointing the appellate authority under section 71 of the GMP Act will be placed by him on the next day of it, as Secretary of has accepted the Bora is the case. No question. Don't take till to inform your authority.
My lord, it's even not, if it is also on 17, my lord.
7. Okay. Till it is also that that till 7 right in terms of the order. Yes, copy.
My lord, call for that letter 6-4.
Speaking one is speaking order. You are required to hand over the speaking order. In this list, his name is there. Not.
Yes.
No, in this letter, it's not there.
No, his name is number 1. My
No, Arunabha Das. No. Let me go to her. Minutes of the meeting, conference, or petitioner. Now let us read the speaking order. You are handing me two things. Okay. Minnesota meeting held on 23. Then for permission for open health court. So they are requested to participate in open e-tender to be held shortly for the same.
My
Now,
lord,
when it was held.
my lord, just I would explain here. This particular order dated 21/3/2023 is relevant to another two subject matter of that our earlier read, my lord. Three subject matter is there, my lord. One is the refreshment room, which is before your lordship. Another two, one Dala and a tea stall. My lord, this particular order is in relation to Dala and tea stall, which were directly carried out by the railway. But IRCTC is taking care of the refreshment room. So, my lord, this order will not cover us. And second, my lord, I am saying that order of the division, learned division, honorable division bench, my lord, 106. What has happened, my lord? Here, this particular speaking order relates to minor categories, minor units. And our is admittedly, my lord, this is a major unit. And in the order of the honorable division bench, my lord, there also it said, and my learned senior friend also said, my lord, therefore the said order would not cover the case of the writ appellant so far as the refreshment room is concerned.
Because what has been placed by Mr. Sahuela, the previous.
Yes.
My lord. 1 minute. 1 minute. Explain and you will explain that we put a division bench.
Yes.
Right? Where is that order?
That relevant is 106, my lord.
106. It's not 100. Not 106.
It starts from 104, my lord.
No. Last order. The writ appeal.
Writ appeal order is at 100.
Tender process as regard.
Yes, my lord. The appellant
where
is
is that?
left at liberty to take recourse. on the
Where is that?
That is at page 106.
106.
Yes. Third line to the from the last, my lord. From the below. Appellant is left.
6.
Here it says, my lord, however, the order dated 10/3/2003 would not cover the case of the writ appellant.
No, that's 106.
so far-
It is second line.
Yes.
First is appellant is running one refreshment room along with a tea stall and a tala
Yes.
at Romia Railway.
Yes.
Next,
Yes.
it is submitted by Mr. Sayola. It is also submitted that press process was initiated only in respect of refreshment room at Romia Railway Station. And the same has been finalized, right?
Yes.
That was a submission made on January 2023.
13/3/2023. 13/3/2023.
33.
Yes.
Thirteen 2000. And so far as the tender process, that was finalized prior to 13/3/2020. So far the documents placed by Mr. Sahiwala on the previous date of listing of this rate. That was culminated into process was finalized 2024, May 2020.
30th May.
3/30,
मतलब May 30. मतलब
I think
May 30th May.
30th May or 27/4.
Oh, 27.
Auction end 27/4. Auction ended 27/4. 3 participants,
Yes.
successful participants.
Successfully Raj Group, my lord.
Successful group. So let us see the later part of the order. Third paragraph. Second paragraph. You submitted to the appellant may be allowed to challenge the decision of the respondent authorities in initiating the tender process for the refreshment room at Rongia railway station by availing appropriate meeting. Right?
Yes.
That was a submission made on your behalf.
Yes, madam.
Because that was submitted, the tender process has already been finalized. And it appears so.
Yes.
Next, third paragraph. In view of the above submissions noted herein above, without recording separate reasons, this appeal is partly allowed in the light of the order dated 10/3/2020. However, the order dated 10/3/2023 would not cover the case of the writ appellant so far as the refreshment room is concerned. The appellant is left at liberty to take recourse of the suitable remedy for ventilating his grievances regarding the fresh tender process undertaken by the respondent in respect of the refreshment room at the railway station, Rongia railway station. So it was submitted on 13/3/2023 that the process has been finalized. Then you said that I'll challenge this. Liberty may be allowed to challenge the decision.
Yes. My lord, it said it is
Then-
also, it is submitted, process has initiated only in respect of refreshment room.
The same has been finalized, Mr.
Uh,
Paragraph.
And the same has been final.
Finalized.
Yes.
Not only initiated, finalized.
My lord,
As regards the refreshment room,
Yes.
how much you are paying?
we are paying, my lord, page number 21. Paragraph, my lord, I have stated that in paragraph 20,
Annually.
20, the
Hmm?
petitioner has paid the entire license fee of RGL till 19 November as has been paid. My lord, here it is said that the petitioner said after
How much you are paying per
19
per year?
24,220
Per year.
per annum. No.
Now it is 11 lakh.
That is there, my lord. But at the same time, my lord,
Public property,
Yes.
enhancement of public revenue.
my lord,
Public revenue will prevail over private.
my lord, then again, my
you
lord, I'm
took-
not coming
you
to that,
took-
my lord.
You took too long a period to challenge.
My lord, I would humbly pray, my lord, that this order perhaps is not in the knowledge of my client, my lord. So we have to challenge that, my lord.
Which one?
That the order finalizing that. That copy, my lord, I may be allowed to have a copy.
Because that was, I mean, the fresh tender you did not challenge
I didn't challenge, but that
for
final,
1.5 years. at least.
finalization, my lord, I had an impression because they have applied mine. They have categorically increased my review, that license fee also. I had an idea, my lord, that
See,
implied
25,000 and 11 lakh.
it's there, my lord. But that has been carrying on for long, my lord. Now it has
You have
been,
run the repression for decades.
my lord, that liberty I may be given.
1996.
I will challenge that, my lord, that letter may be given to us, my lord. One copy.
That's the notification Allah will provide.
That will be given by
But for this case is concerned, you took too long a period.
Yes.
My lord, we had an impression, my lord, that they are allowing us because they are taking the revenue till November 2023.
And otherwise catering policy, whatever is there.
My lord, catering policy will not come because it's subsequently to a catering policy, my lord. This agreement. This is a fresh agreement, my lord.
That was about 5 years back.
5 years back, my lord.
Where is that catering?
There was no time frame, my lord, but if we take it reasonably, my lord, it should have been for 5 years. I understand, my lord. So there is also another
123.
food plaza, my
Is
lord.
123.
My lord, food plaza we may not be
And,
covered, but term is for 9 years.
And
So you have annexed this. You are it is within the knowledge. Page 66. It is within your knowledge. Page 66.
This is tender, my lord.
Huh.
Tender is that is we have challenged it. We have challenged
Now 1.5 years.
yes. Tender we
There
have,
was submission that it is finalized.
ma'am, we have no idea about that, ma'am.
Just because of the
Finalization.
pendency of the repetition, they have not awarded perhaps.
But that
The
finalization,
work order has not been issued,
My
but
lord,
everything has been three
yes.
tenderer, successful tenderer,
Yes, we have-
11 lakh, all quoting above 11 lakh.
we have
And
no,
you are running at 25,000 per year.
my lord, perhaps they were not aware of the that award, my lord. So
That is
we'll
different.
make
You
them
have to
party, my lord.
challenge-
We'll have to make them party.
You have not challenged for 1.5 year, at least the NIT.
I said, my lord, because I had an
Because see your pair now.
my lord, they have gradually increased my rent also. So
Whatever.
I had an impression that they may be allowing me, my lord.
Now you have challenged the impugned NIT 16/11/2020.
Yes, because
After 2.5 years.
this finalization, we do not have any item, my lord. Otherwise, you have made party the private respondent also. My lord, backdrop I have already submitted, my lord. Once that NIT was challenged, but that was infructuous because of the speaking order in some other writ. My lord, it said that since because my lord, this NIT was floated in pendency of a certain stay of this honorable court. So my lord, we have challenged that.
Whatever the highest forum was the division bench.
Yes.
Whatever happened, happened. But the highest forum was the division.
Yes. Yes.
There you took the liberty to challenge because of the submission made by on behalf of the
Perhaps,
IRT
perhaps
on that date, 13/3/2020.
Then my lord, perhaps
It was submitted before the
Yes,
court.
this
And it is
finalization and awarding, we have no
It
idea.
is not a wrong submission,
True, ma'am.
as it appears from the document.
Yes, yes.
Then you took the liberty.
Yes.
Now it is too long a delay. Tender process has to be challenged within very short time.
My lord, we
1.5 years, it is too long.
had an idea, my lord, that they are allowing us. We do not.
You are a prudent businessman running a property, railway property for decades, 3-4 decades.
My lord, I may be given liberty to that.
It is up to what liberty now?
My lord,
One liberty you have taken from the division bench.
Yes. Now, my lord, this
And this court is of the view that 1.5 years is too long a period to challenge.
my lord, that may not be, my lord. That will be because we the whatever it is, my lord, we want to press our case for the last time, my lord.
Now you have to observe to decide this
Because
repetition.
that order of finalization and awarding that to the parties, that only, my lord, maybe served to us so that for liberty.
But so far as this is concerned, this repetition, we are of the view that at least we can issue notice.
So my lord, can it be possible, my lord? We have no other option but to withdraw it because we have to challenge those.
That is up to you.
Yes. Then, my lord, only where I am aggrieved, my lord, or where I am concerned, my lord, because in the meantime, they may, my lord, take over the property, my lord. So,
Yes, Mr. Saha.
Now that refreshment room is to be, my lord, modernized. We have to, my lord, do it as per the policy. We have to modernize it, my lord. Kitchen is also modernized. Taken, my lord,
That copy will be furnished to you by Mr. Sayawala. So far as there is concerned, we can issue notice only.
My lord.
It is up to you.
My lord, that can be done. Yes.
Copy
lord.
will be furnished.
Yes.
Hard. It is up to you. It is challenge or not to challenge, it is your decision.
My lord, I am,
We have to
I understand, my lord.
proceed with this
Yes.
requisition. Third, Mr. T. Chadurika, Director of the People. Mr. H. Gupta, Director of for respond number 1 and 5. The GN Sahawan said by Mr. N. Anik. Turning out, sir.
Yes.
Turning out. Indian Railway Catering and Tourism Corporation.
No, 2 to 4.
RCEC for the
2 to 4.
for the number 2, 3 and 4. The petition has said in this petition, one of the petition has said a notice. What's the date of the
Notice, NIT, my lord,
notice which you have filling?
29.
In the prayer, no date is mentioned.
29.
11/21.
Wait, which page?
Page 66.
No. Impugn notice.
Impute is 119, my lord, page 29/4.
119.
119, my lord.
119. 29/4.
29/4/2024.
Impugn a notice dated 29/4/2024 issued by the respondent of court and a e-tender cum auction notice dated 16/11/2000. Go to within bracket before and insert it or second before. By the notice dated 29/4/2024, comma, the petitioner has been asked to vacate a refreshment room at Rongia Police Station.
Railway.
Rongia Railway Station on or before 13/5/2020. By the e-tender cum auction notice dated 16/11/2021, comma, which were invited for engagement of a service provided for operation, comma, maintenance and provision of catering services in through refreshment room at Rongia Railway Station for a period of 5 years. Para. It is a case of the petitioner that since the time of his father, comma, the refreshment room at the Rongia Police Station, railway station, is being run by the family of the petitioner for a number of decades. Yes. After the respondent railway authority has notified a new catering property in the year 2017 on
2nd February 2017. 20 February 2017.
2002-2007,
Yes,
comma, a tripartite. Where is it?
that is page 51, my lord.
A tripartite
Date, date. Date is on, my lord, 10th of November 2017.
agreement was entered into on 10/11/2017 between the respondent NF Redway, comma, the IRCTC Limited, and the petition in respect of the replacement room the petitioner has projected that the tripartite agreement does not contain any termination period, and on the strength of the said tripartite agreement, comma, the petitioner has been running and maintaining the refreshment room at the Rongia railway station, Ilgate. Yeah. A number of litigations ensued thereafter, comma, which culminate in a writ appellate proceeding on 30/3/2020. On that day, comma, a number of writ appeals, comma, writ appeal number 47 of 2023, comma, writ appeal number 54/2023, and writ appeal number 89 of 2023 were disposed of. The writ appeal, comma, writ appeal number 89 of 2023 was deferred by the present petition in respect of the refreshment room, comma, a tea stall and a dala at Rongia Railway, right?
That's yes, my lord.
When the writ appeal, comma, writ appeal number 2023 came up for consideration on 13/3/2023, comma, it was submitted on behalf of the respondent IR. The tender process initiated by the e-tender company stated the tender process initiated in respect of the replacement at Romeo Agency, comma, apparent by the e-tender auction is 67,000, comma, had, comma, in the meantime, it finalized here, comma, the case of the redevelopment in WA number 89,000, which is not could be not covered the observation direct made the other PDP which were disposed of. If it was subsequent to such submission made on behalf of the respondent IRT, comma, the learned counsel for the redevelopment in WA number 89/22 had submitted that the redevelopment be allowed to delay the decision of the respondent IRC railway in initiating the tender process for the replacement by availing appropriate remedy. The read appeal, comma, WA 89/2000 was disposed of the observation that was disposed of granting liberty to the read appeal, that is the present take recourse to suitable remedy for its demands regarding the press tender process undertaken by the respondent authorities in respect of the replacement room at the Rogia village. It is in the above backdrop of best, comma, present before to notice regarding the learned counsel for the part are also hard on that. By on a query made to the learning counsel, it is submitted that to the tripartite agreement, comma, the petitioner disposed if an amount of fees about 25,000
24,000.
approx.
Yes.
Per year in respect of the request. On the other hand, comma, Mr. Taiwan, senior counsel for the respondent IR has submitted that pursuant to the e-auction, pursuant to the tender process initiated by the e-auction test, e-auction come, the e-tender come auction dated. Comma, bids were received and after processing the bid, comma, 3 bids are found to be responsive. Full stop. As per full stop, the rank list of the three responsive was published by auction notification. And as part of the auction notification, all the three responsive bids have quoted an amount. What is it? License fee or what? Yes. What is it called? License. Have quoted a license fee above rupees 10 lakh 63,220. Above. With the highest being rupees 11 lakh 13,220.
But now, my lord, in fact, he has not handed over the assessment room. So,
it is
actually, my lord, now they could not complete the process of, my lord,
It is noticed that
so
after liberty was granted to the present petition in the writ appellate proceedings, in WA 89/2000, when it on 13th 2000 to challenge the tender process initiated by the e-tender company. The petitioner present petition has challenged the same after more than 1.5 years thereafter by the instant considering the above
My lord, it would be 1 year perhaps. my lord.
the
1 year difference. 1 year, 2 months.
1 year.
My-
2021
Yes, my lord, we challenged it earlier.
is 3 years.
We challenged it earlier.
Oh, it's your
Yes. My lord, it's not that we have not challenged, we have challenged it, but
it's good. That's fine. Any so many students for staying or grant of any interim leave in respect of the replacement room at the Rumia Railway.
my lord, this submission, my lord, that this part of the judgment, my lord, they may take it that as a, they may oust me, my lord. That is the thing, my lord.
What do you want?
My lord, no course till this, my lord.
Oh.
No, my lord.
Since the petitioner is position of the replacement has not been this court is of the concept that the that will allow reasonable passing from I have given the option, I have given the option to you, you know what to do.
Obliged.
1 week I have granted.
Obliged. Deeply obliged.
No, Mr. T.J. Mohanto to put up. Yes, Mr. Mohanto. No, just to find out from your side because I learned it. Madams are not very. Just to otherwise no issue.
My lord.
Come to page 51.
My lord.
There was some submission, paragraph 3. The learned senior counsel appearing on behalf of the petitioner submits that if the additional deputy commissioner Kachar Silsor, that is the appellate authority, disposes of the appeal within a period of 1 month from the date of the instant order.
My lord.
Okay, so far so good.
My lord.
Some demolition part. Now come to that page 53.
My lord.
The letterhead. In the court of so and so, Chief Executive Officer Kasar Jila Police.
He is assigned, my lord. Now he is assigned. Same, my lord. Same.
In charge.
He is, my lord. Para 22.
He should have mentioned it.
Para 22, my lord.
Huh?
Yeah, he should have mentioned it, my lord. I am mentioned in para 22.
He is signing as Chief Executive
My
Officer
lord.
Kasar Jila Parishad.
He should
Letterhead is.
He should have mentioned it, my lord. In para 22, I have mentioned, my lord.
Otherwise, if he does not have any authority, how can he pass out? That is the simple question.
He's the appellate authority.
Page.
Para 22, my lord.
Paragraph.
Page, my lord, 12. The petitioner begs to state that after the order dated 4/11/2020 passed by the Chief Executive Officer, Zilla Parishad, come appellate authority of the Silchar municipality, but did not properly executed the. So that appellate. He is respondent number 4, my lord. He is the ACS officer, my lord. He is, my lord. He is assigned, my lord. I'll discuss with him.
No, I had an interaction. They have said he has
He's
been
the,
assigned.
he's the assigned. But yes, he should have mentioned it, my lord. Comes
Because his letterhead as well as under which he has signed,
Yes, my
Chief
lord.
Executive Officer Kasar Jila Parishad.
He should have mentioned, man. Exactly, my lord.
But when I went through last night, I was also confused.
But he should
Then I
have
had a talk.
applied his mind.
My
At
lord.
least basic.
Yes.
There appears to be non-application of mind on his part. Heard Mr. T.J. Mohan. Senior counsel assisted by M.S. B. Sharma. Learned counsel for the petitioner. That is why I asked for.
My lord.
And Mr. Goswami, you were there. And Goswami, Junior Government Advocate Assam Patel, respondent number 125. And Mr. S. Dr.
6 and 7.
Learned Senior Counsel assisted by M.S. S. Musahari for the respondent number 6 and 7. The petitioner has approached this court by the instant repetition, agreed by non-implementation of the direction made in the order dated 4/11/2023, Annexure 70, which was passed in deference to an order dated 1/6/2023, passed in a repetition WPC number 6145/2020. If you notice, returnable in so and so date. As Mr. Goswami and M.S. Musahari as a case accepted notice not to the petitioner shall take case for service of notice of the response number 8 by
My
respect to review within
Deep look.
Obliged.
Talukdar available? Yes, what is that?
My lord, lordship, kindly, my lord, see at page 18 by resolution dated, my lord, 28,
Page, which repetition? 2279?
my lord, 2279.
Okay. Page?
Page 18.
18.
18. By resolution dated, my lord, 28/3/2024. My lord,
Tara Mia.
my lord, the respondent number 7 has been removed by
Is
way
the
of, my lord,
agenda. Okay.
no confusion motion. Despite that, my lord, he is, my lord, holding the post. And my lord, finding no alternative, my lord, the appellant, some of the appellant have, my lord, filed an appeal before the registered cooperative society, narrating the, my lord, facts. But
What are the facts?
yes, page 22.
Page?
Page 22, my lord.
20. Open. Then after resolution was sent to assistant register.
He has
Then
not,
he has not given
taken any
approval.
action. Yes.
So you preferred appeal.
Appeal before the register.
Before the register. What is the other case?
Well, the other case,
Okay, let me read. Mr. Talwar, in the other repetition, I think the events like this, who was the previous chairman? Abdul Sobur. Right, let us go by the name. Otherwise, Abdul Sabur.
Well,
He was removed by resolution. Then matter was directed to be inquired. And it was ultimately found out that after voting, some members changed sides. Then on the strength of that, the register has passed an order that Abdul Sabur would remain as chair. Right? Then the writ petition was moved. The other one. That impugn order that Abdul Sabur would remain as chairman has been stayed until further. It has not resulted into a situation that the Abdul Sabur is not a chairman. His restoration to the position as chairman has been stayed.
the consequence is he's not a chairman. He's not a chairman.
But it is not quashed.
Even
There is difference between quashing and staying.
the stay on.
It is a stay order. So, suppose
That order is stay.
that order is stayed.
Yes. But your lordship did not say that he will not function.
No, he is kept outside to perform the function of the chairman. But if the writ petition is dismissed, he will come back. Why is the question of appointing another chairman?
No.
Have you?
Yes.
Have you understood the slight thing? Suppose a man who is serving as a headmaster. Now he has been suspended. He is not out of the post.
Not attained finally.
He is kept out of the purview to discharge the function. So there is no question of appointing a full-time headmaster till his appointment is set aside.
He may come back also.
He may come back. So you cannot appoint a full-fledged headmaster in his place. Right? Now, taking analogy from that, this Abdul Sabur has been kept out of the purview to discharge the function of the chairman of the society by the stay order. The order is not passed. Where is the question of bringing another chairman?
Not good. Vice chairman will function.
Then all this exercise. Have you understood what I am saying?
Yes.
They are moving another resolution to remove another chairman. What is the legality of that chairman?
The board is doing all this.
What is the legality? How this Taramia has become chairman?
Earlier,
By virtue of the interim
No,
order.
after the stay, you have not become chairman. Sir.
Earlier, before this came, when he removed from the board, the position of law, the remaining board member is by way of a managing committee meeting, my lord, they have selected one chairman. That's what the
One
procedure.
cannot be the
That has been already
that
approved.
Taramia, Abdul Sabur was removed.
Yes.
By resolution.
Yes.
Of the board.
Yes.
Then, otherwise that was by majority.
Majority.
Right.
Yes.
Then suddenly existing registered cooperative societies found that few people changed sides. Now more are in support of Abdul Sabur. Right?
Yes.
Resolution has attained finality. After that, they have changed sides. Now more are in support of Abdul Sabur, less are in support of Taramia. On that strength, the register has passed the impugn order,
Yes.
which has been stayed. But register has reinstated Abdul Sabur as the chairman,
Abdul Sabur.
and which has been stayed
But it's
until further order. Where is the question of appointment that it is not wiped out?
not waived, but the after passing the order by the registrar, prior to that, after the removal of the earlier chairman, the another board meeting has been constituted. In that board meeting, my lord, the
But without
amongst the
approval was not granted.
approval was granted.
Where is the grant?
That was granted. So, at 2, my lord,
Please find out the consequence is not that once order is stayed, appointment of a chairman is stayed. That does not mean that somebody will come and discharge full charge. It cannot be until his fate is decided. No, he is suspended. His order of restoration has been stayed, but he has not been removed. So where is the question of another chairman, full-fledged? One could be in charge, but like in charge headmaster. All these litigations. But super
in my lord,
In
section
absence of my lord
43(6),
chairman, vice chairman can function.
43(6), my lord, is clearly
no, I am not satisfied.
yes, my lord.
Yes.
My lord, in second case, my lord, initially the no confidence motion was moved on 27/9/2023 and was removed from the post. Thereafter, the vice chairman was continued to hold the post of chairman. But the earlier ousted chairman had an appeal before the registrar. And that appeal, after inquiry, was dismissed. That was dismissed on 29/11/2023. After
Part of the record?
Yes.
Which one? In Taramia?
Taramia.
Where page?
In Taramia, page 35. The relevant portion is page 37. Under the above stated facts and circumstances, it is clear that the majority of the BOT members of your society are not able to run the society under your chances, and hence the resolution adopted by number so and so by the 30 numbers will be still in court, and thus your appeal
That has been interfered with
Yes.
by
So,
the
my lord,
order.
subsequently, my lord, thereafter, after this dismissal, my lord, on 4/12/2023, that is at page 38, a resolution was adopted. Due to the vacancy of the post of chairman, my lord, the new chairman has been selected. And that was approved by the ARC. And that has been done pursuant to the section 36, subsection 2. And even in section 43, subsection 4 is also there.
Chairman. Taramia chairman.
Yes. Taramia has been newly elected as chairman after removal of the earlier chairman. Thereafter, he again preferred an appeal before the rest.
That was 21
Yes.
December 2020.
Yes, madam. And
there
the
no
input order
confidence
passed on
motion.
21/12/2000.
So no confidence motion against the chairman is hereby found invalid.
Yes. That input order has been challenged before this honorable court. And this order has been stayed. And meaning thereby the Taramia, who is already selected by amongst the board of directors, which was
Okay, issue
approved by
notice
the
in the
ARCS.
secondary petition.
My lord?
Already notice has already been issued there.
My lord?
Notice
Yes.
has already been issued there.
Already.
Issue notice in this case.
Yes. And in this case, my lord, I have already entered my appearance. Even then, my lord, the no confidence motion, they have submitted the requisition to the secretary. That is totally not in consonant with the law, my lord. The 43(2) is clearly reflected that the requisition should have been submitted before the chairman. And the majority prescribed in 36(4), my lord, 3/4. Meaning thereby, out of the 15 board of directors, 12 board of directors as the majority, my lord, to remove any chairman or vice chairman, whatever. And in this writ petition, my lord, they have tactfully filed this writ petition without disclosing any fact. By suppressing the material facts, even this present case, my lord, the Taramiya case, they having the knowledge.
Report of the majority of the directors present and voting.
No, my lord, in this, I have the judgment, my lord, that has been analyzed clearly that the total majority member 12 is required for removing a chairman and vice chair. 9, 10, 11 also not the majority.
Will issue notice at this?
Yes, sir.
Heard, Mr. M.U. Mondor, current counsel for the petitioner. Mr. S.K. Chief Secretary, Secretary of the Mr. So the government petition for respondent get up and standing on cooperation part number 225. Secretary Society?
Yes.
You
No, I am the respondent number 7.
also heard Mr. R. Islam. Learned counsel who has entered appearance on behalf of the respondent number 7.
Yes.
Para the petition from attaining number are members of Kurmar, Mr. Kurmar Mobile Home Cooperative Society. The petitioners have stated that a resolution of no confidence was passed against the present chairman of the society, that is respondent of number 7, in a meeting held on 28/3/2024. So the petition, demands of the petitioner is that the requisite approach to the resolution removing the respondent number 7 from the chairmanship of the society has not yet been accorded approval by the respondent authorities in the corporation. As however, a petitioner has taken for after upon the respondent number 6 by referred to place the case along with the writ petition of PPC number 819/2024 after court. The parties may file their respective counter affidavits in that.
But in the meantime, my appeal is pending before the authority.
You are coming before this court.
Since they have not taken any action, so my lord, there is no alternative forum.
I cannot pass that order already until further order in the other one.
In fact, my lord, as per my information, there was
Until
a
further order, stay order.
Yes.
For indefinite period has been passed already.
Yes.
But now, my lord, till then, my lord, pending, my lord, the appeal, the registrar may be, my lord, directed to dispose of my appeal. That much can be, my lord.
Oh. Until further order is there, just because a writ petition is filed, why should we observe that?
Master.
This court has already granted interim stay until further order.
That man has already.
I am not going to revise that until disposal of the writ.
Master.
Obliged.
Yes, madam.
Lordship, I have received the instruction. The petitioner has informed me that after the rejection of the application for mutation, he has preferred for an appeal. And then one number was sent to him, but till date, he is unaware that whether his preference for appeal has been registered or not.
Do you have the number?
Yes, I have that number.
Panish to Mr. Gupta. Hard MS
A Bora.
A Bora. Learned counsel for the petitioner and Mr. Anybody? Okay, for the sake. Learning counsel for the department for the number one. Mr. N. Gustavi learned MS Bora learned counsel for the petitioner submitted that after receipt of the information that his mutation application has been rejected, the petitioner has preferred an appeal under the Right to Public Services Act 2012 and a number has been generated in that regard. Number.
ID.
ID number. What is the ID number?
DO.
Okay, give it to the group. Application number so has been generated in that regard. Mr. Shall obtain instruction, is to obtain instruction whether the appeal preferred against the order of rejection of the mutation application has been registered, has been numbered and registered or not. Case second. Right. If the appeal is registered, closed.
For episode item number 7,
Malaya is getting ready, maybe this was my reading ready.
Reading is ready. What is the issue?
So the
What is the
if fact of the case is that the petitioner, he was an driver in the on contact OS basis in the establishment of Devar Court in the year 2006. In the meantime, a post of peon was fallen vacant, so advertisement was issued by the presiding officer Devar Court calling for application. The petitioner and 15 others, including one Noyanmani Sharma, has applied for the postman. In interview, petitioner was placed in the first position and Noyanmani was placed in the second position. In the what happened? One mile of driver, the driver of the Devar Court, he was placed under suspension by doing the departmental proceedings. Also, the post of driver was fallen vacant. So to make the arrangement, the petitioner, instead of who is working as a driver already, instead of appointing him as peon, was appointed as the driver minor. And in the post of peon, Noyanmani Sharma was appointed. The things are going on from 2006. In the 2014, the driver who was suspended, he has filed his petition before the Honorable. The petition was allowed and he was reinstated, ordered to be reinstated, who solved backward execution. Therefore, he was, when he has to be reinstated, he was reinstated, he was posted in the place of present petitioner, who was the driver. Also, he was reverted. So in the post of peon, in respect of which he took first position, he was posted in that position. So there is no vacancy for Noyanmani. So Noyanmani one Bipin Bujal peon, he took voluntary retirement on health ground. And in that post, he has been absorbed.
Noyanmani.
Noyanmani was absorbed in the post of Bipin Bujal by reverting from the post of present petitioner. Sorry, the things are going on in the year 2017. The presiding officer has issued so-called notice to the both Noyanmani and the present petitioner. The proposed is seven.
Page 25.
Page 25. 25. Propose my thought. It is page 25 propose notice. The based on the pay protection application of the Devar Court employee Sri Sanatan Deka, it is seen that the court employee Sri Timbeswar Deka was appointed in the post of driver
Hmm.
in the year 2006. After taking interview for the post of peon, he was brought back to the post of peon in the year 2014 with pay protection. The which was against the rule. Therefore, as because his appointment and pay protections are not in accordance with the rule, and hence he is asked to propose as to why excess payment received by him as pay
So
protection.
basically two things. Pay protection order has been withdrawn. Pay protection order has been withdrawn. And there was a direction for recovery.
Yes, direction for recovery the excess amount.
Now, which one you are attacking? Which one? Assailing which one?
Both. Recovery.
Both for pay recovery.
Recovery, yes, because in November,
Only recovery part.
November has filed a separate petition for his termination. That petition was allowed much. He was reinstated.
So he is serving.
Yes.
He is serving in another post of peon.
Now he is serving my daughter.
No, Noyanmoni is serving in another post of peon.
Peon Bujau Bipin Bujau Bora. According to presiding.
So he has no issue.
My lord.
Noyanmoni Sharma has no grievance.
No, he has filed a writ petition, and that was allowed, my daughter.
Right. But your position
Yes.
in the post of peon
Peon, yeah.
is in danger. Not in danger.
No, that is
Not in danger. Or you are aggrieved by the withdrawal of the pay protection order
Yes.
and the order of recovery.
Order of recovery, my lord.
These two.
Recovery.
And mainly your grievance is the order of recovery.
Recovery, yes.
Okay.
Because the peon post of peon, pay scale of the peon is a bit lower than the.
Now at present, what you are enjoying?
I am now enjoying the death scale because I am giving pay protection. I am now working as a peon, but I was given pay protection because since 2006, I
It
was
has been
giving-
stayed or what? Recovery has been stayed. The pay protection order has not been stayed. Okay. Bidding is exchanged. Then Thursday we can dispose of it. Thursday. Thursday. We can dispose of.
Yes, my lord. I have got to Supreme Court ruling. Pay cannot be recovered, my lord. Pay cannot be the forget employee if he grows salary.
Rafiq Masi.
Right or wrongly for more.
Rafiq.
Yes, more than
Rafiq.
I'm giving my.
Yes, Mr. Da. Rafiq Masi will be applicable.
So far as recovery is concerned, I leave it to your lordship. Rafiq Masi is there, but so far as entitlement with regard to the pay.
That has not been stayed.
Yes.
That has not been stayed.
No, yes, that has not been stated, but he is not entitled for that pay of driver, my lord. That is sure.
Okay, we'll give it final consideration Thursday.
Fine.
Since meetings are already there. Yes, what's the decision?
This is one, my lord, 1994, Supreme Court.
Habib Ahmed or what? What is the name?
State of Punjab,
White washer. White washer.
Here, my lord, the
White washer or what?
White washer.
Supreme Court has given the guideline under what circumstances pay cannot be recovered. My lord.
Okay, leave it for give a copy to us.
Page 18, my lord.
So it to
Under
Mr.
my
Das.
lord. Under my lord, 2015, page 34.
Yes, what is the name?
In both these cases, the Supreme Court held that pay once paid without a fault on the part of the employee, it cannot be recovered. Even after more than 5 years. Now petitioner has enjoying that say up to 11 years, my lord. After 11 years, the notice was issued, my lord.
Shyam Babu Sharma and 1994 to exist.
Yes.
One. And Rafiq Mas. Hired. The case Sharma. Then it comes for application. Labor, employment, and Gusami. Junior government supporter, one Mr. Mr. and setting up. One day I put for harassment number 3, 4, and 5. 3, 4, and 5.
3 and 4, my lord.
Register labor code.
Yes,
Register
yes.
labor code UP or Mr. Gupta? Okay, 5. Gupta. 1, 2, and 5. He's not a judicial service.
It's not a
Okay. And say that 3 and 4. 4 is presiding.
presiding.
Land transport of parties.
My lord, normally judgment can be seen. It is a covert judgment. I have filed with my reply to that.
Thursday. Release the case.
Part of the judgment was already set into order.
Release the case. And I never will.
Item 19.
Yes, not or not. Supernumerary. Who is finance? Is a party or not? Party. But this way, that way, this way, that way. Unending process. And we should call all of them instead of writing correspondence. We should make assemble all the secretaries. Writing queries after queries. One department making queries, the other department responding with another set of queries. What is going on? This is going on from 2019. We're not playing ping pong game. Table tennis. Resubmit, resubmit, resubmit. What is this going? Call finance department. they don't know how to submit proposals and all. It is going on, Mr. Das. It is long. It's like table tennis game.
Within the department.
Yes. One department taking another 10, one department. He retired which year?
17.
17. 7 years. Too much. Since when it is going on? Where is Mr. Nath? Nath. Call him. Call him. Yes, no, we'll take up. Call him. Oh, that one. Yes, Mr. Talukar. Not on a motion. They have decided to give it a thought. Because in the meantime I was not there. It is assigned to me. Perhaps. Yes. I have to dispose it on. But not on a motion. Something you have to 35. Hearing this. Hearing this. No. That's it. Thirty-five is, I think, Thursday. Okay. Yes.
Directed the respondent to file.
My lords, what had happened basically, they have filed an additional affidavit. And what the materials I could have brought by affidavit, they have annexed to it. Everything is there, my lord.
No,
The notices are there. Vehicle has been confiscated. Only information I tried to find was as regards notice. Notice has also been complied. Only issue is, my lord, the conservator should have taken a call. But he sent back the file to the DF conspirating officer, my lord. And there is also imputation on me, my lords, that while these matters moved, my lord, on receipt of the advance copy of this notice, my lord, of this petition, my lord, I had instructed the petitioner, the respondent authority to pass confiscation order. That is there, my lord. Paragraph 13 of the additional affidavit. Paragraph 12, 11.
Show me, madam, any law that mere filing of the petition,
My lord.
mere filing of a petition challenging certain process will preclude the state from passing the order in the process. See, the confiscation proceeding, whatever, was initiated, was in progress at the time of filing the writ petition. Is it not? What you have challenged in the writ petition?
There is any grievance, my lord.
No, particularly directing him to pass appropriate order under section 49A. 49A. There is a pair only. Forest regulation. No, what you have chilling? Page 70.
Since my
Page 17. Prayer.
my lord,
What kind of power is 49A?
yes,
What kind of power?
Yes, yes.
my lord, in the Assam Forest Regulation 1891. And 49 all to release property, seized and any forest not below the next or supporting the fifth part machine address puts cattle road, chains or any other implements that and 49 is the same on the execution by the owner or for if and when so required. Getting right.
So this is a discretionary power. This is a discretionary power. Otherwise, the mandatory provision is in section 49. Mr. Gogoi, section 49 provisions are complied with or not?
And they have been complied with. So, course notice has been issued. They are part of the writ petition also. And my lord, the Lordship, recall Lordship has passed one order in Maruti Timbers. So that has been taken care of, and my lord, these all orders have been passed by the authorized officer. No seizing officer business is there.
Okay.
And vehicle has been, notice has been issued, my lord, they had appeared also, which they have stated that they have appeared, but they have not signed those documents, their statements.
Appearance is one that complies substantially.
Yes, my lord. And there is also averment, my lord, that they have not received any notice, but they have appeared, my lord. The vehicle has been confiscated and they have a remedy, my lord, before the district judge.
Appeal.
Yes, my lord, because the
Now what
nature of
substantial violation you are alleging? What is the violation of the statutory provision?
The procedure.
Yes, procedure.
Procedure.
Statutory procedure. What kind of violation?
As per my lord,
49 years.
in my
49.
the Assam Forest Regulation,
Forest regulation, right?
no order confiscate any property under
Subsection
my lord, 5A, my
5A. Yes.
My lord, this sends an intimation in the prescribed form about the initiation of the proceeding for confiscation of the property to the district being on account of which visa has been made. The issue a notice in writing in the person from whom the property is seized and to any other person.
Where is the first notice?
My lord, what has happened?
Where is the first notice?
My lord,
33, ma'am.
33. Just below, at the bottom. Chief Judicial Magistrate. Copy forwarded for information and necessary action to the Chief Judicial Magistrate. And it is so called within 30 days. Okay. B. Issue a notice in writing the person from whom the property is seized, and to any other person who may appear to the authorized officer. This is by DFO, who have some interest in the authorized both friends. Affords to the person C, referred to in clause B above, a reasonable opportunity of making a representation. So 30 days was given, right? Now, what is the statement that he received notice and appeared? Additional affidavit.
Main petition, my lord, parent petition, paragraph 14, page 10.
14.
14, 15, and 16.
Issued a notice directing the another letter was appeared. Dispose of the hard expired. Appear and file his reply. File his reply. Give to the officer. Where is the confiscation order?
And it is with the additional affidavit. Page 18. Annexure. And also, my lord, the indication that he had appeared at page 14 of the parent petition, para 24.
But Mr. Gogoi, additional affidavit, annexure 14.
Yes, ma'am.
If this is the total order,
No, no. This is a part, my lord, they have annexed. I had that original record with me, my lord, it is sent back. I can produce it on the next day.
because if this is the order,
No, this is not. This is only the tail, my lord. Head is somewhere else.
then it suffers.
No, no, this is not.
Then it will suffer.
No, this is not order, my lord, I can say.
This is not in conformity
My
with
lord, see at the bottom, my lord, page 8 of 8. So there are 7 preceding pages.
This was given to me
On the day of
earlier-
motion, my lord, I had given.
in an earlier.
Then you bring that
I'll bring
order
the
on
order.
record.
It will be convenient if I file the affidavit so that we can.
Affidavit, my lord, the everything which I would have
Bring
brought
that
on record.
the one the confiscation order on record.
Yes, I can.
That would suffice.
Yes.
If it is a region order running into 8 pages,
Yes, madam. Yes.
it will suffice.
Fine.
Right?
Yes.
Your lord.
You bring it on record.
That can,
Then,
I'll
They
bring
have
that
done it
con-
partly.
Yes.
Immediately,
I'll bring those total 8 pages on record.
sir, in that case, we have grievance, we can
Let him find.
come to
We'll find out whether you have any grievance or not.
My lord, date may be given
what
next
time?
week, madam. I can.
Next week.
Next week.
Shall we pick the date?
Yes, madam. And we
Hard to- As for and especially with started studying environment for all the rest. Also, the authorized has already passed an order of compensation on 8/7/2020 and he granted 2 weeks time to file a counter affidavit in order to bring the state order of confiscation on record. As sought for by petition on forwarded copy, but the
Lordship is potentially non-consideration of the provisional release of the vehicle. The last occasion they have given an order has been passed by the joint commissioner.
you have received copy.
Lordship, because to what
You have received the copy.
Lordship,
What's up?
Lordship, some instruction is awaited from the client, so madam will pass over for the day and fix on next week.
What was the order? What was the purport of the order?
Lordship, it is not with
In your favor or against you?
against
Against you. Okay. Heart Sister L. Mohanlani and Miss
M. Dek.
M. Dekal Learned Counsel appearing for Mr. Mikael and for response. All respondents?
Yes, Lord.
Okay. Mr. Mohan has submitted that petitioner, he is yet to receive instruction as regards the order passed by the respondent authority. He is yet to receive further instruction as regards the order passed by the respondent authority during the pendency of the writ.
how long?
My lord, this is an application for appointment of arbitrator.
Petition and affidavit in
Arbitration
reply.
petition.
Affidavit
Arbitration
in reply.
Yes.
You have filed. Where is the affidavit?
They have filed 2 loose papers against which I have filed the reply.
Lord, against the loose papers, my lord, they immediately filed a reply, my lord. I have to
They-
file an affidavit.
They are not filing
That
the
is an
affidavit.
instruction. I have given instruction, my lord. They are so quick. Now what to do? my lord?
Affidavit in reply.
There is against loose. How can
Loose paper.
Yes.
They are not, stand is not on record.
Yes, my lord.
How can you file affidavit in reply?
That is not
He has
as per-
served the copy, my lord.
That is
in the
instruction
court
to the
itself,
court.
my lord.
That is the instruction to the court, my lord.
Just to proceed with the matter, but not, yes, you filed it.
My lord, I think this is not as per process, my lord. If I may humbly submit.
Let
I
him
think
file
they
it.
you should file it.
And my lord, at the outset, my lord, but another thing is there, my lord, there is a covered judgment. My lord, regarding the claim, there is already a decision of this court.
My lord, one decision in his favor, another decision in my favor. And my decision has got finality. His decision is still going to be challenged as per my
And
instruction.
there is nothing like it. That is the only decision, my
How
lord.
can you say nothing like that?
My lord,
The party
they-
is
Where
going
is
to
your
challenge.
decision which attend finally? But something has to be brought on record
Yes,
by railway.
yes.
So, my lord, prima facie, my lord, there is a contract agreement at page 81. My lord, the agreement says that if the my lord, claim for arbitration is more than 20% of the contract value, the dispute will not be arbitrable. There is a specific bar in the contract. And the
Which
page 81. And
81.
page 81 is the contract agreement, my lord. 16.2.
You are. Page 81.
Page 81 more clause 16.2.
So,
This clause has been upheld in the judgment, my lord, which I have.
what is the contract value?
Contract value, my lord,
8 crore 78 lakh.
8 crore
Where is that?
78 lakh.
At page, my lord, 39.
39.
20% of it fee. 1 crore.
Contract value. Yes. Then what is the claim?
Claim is, my lord, at page 17.
Okay. Now, what is the law? As per what?
For this judgment, my lord, paragraph
As
20.
per there are two judgments now.
Yes, two judgments. In my judgment
As
also,
per
this has been considered.
the judgment,
My lord, in ATW, my lord,
ATWES, which paragraph?
same party, my lord. The paragraph 23 is the conclusive part, my lord.
There it was clause 10.1.
Yes, there is the wordings are same. Clause number is different, but language is same.
And what is your?
In my case, the clause number is similar, but some difference were there in that contract. Some mistake was there.
Here also the contract value would be more than, my lord, 41%.
Where is that finding regarding?
That finding, my lord,
No.
the,
Your case it is 36.6.
yes, here, my lord, the instruction which I have given, my lord, must be on record, my lord.
Where is the observation? In the other judgment?
We have only one. I have given.
So this is the
Yes,
reply which
I got, my lord, I got.
You have copy, another copy?
Yes, sir, yes. Sir.
Where it is
my lord.
observed,
Paragraph 16, my lord. The entire arbitration clause is quoted here.
where is exceeding 20%?
Yes.
conclusive, that judgment, my lord, the matter was referred to the tribunal to be decided. There was no adjudication on this point. The GSR matter which my learned friend is referring to.
I'm looking at for the first time.
My lord.
Where is the finding that it is the claim was above 20%?
Yes, yes, sir. Paragraph 9, your lordship may kindly. Then in 11, observation is there. And
No, where is the finding?
Finding
You made a submission that there were seven separate claims.
17
Each claims were below
yes,
20%.
17 mile. In support of her contention that clause 47.
I have read.
Yes.
Now, where is the finding? That is your submission.
Yes.
Is that paragraph 57. Correct. Paragraph 57. It was left to the arbitral tribunal. Paragraph 57. Page 203 of the reply which we have.
Whether Mr. Gupta, you need to file any affidavit?
But
You want to bring this because this otherwise.
I'll bring it.
Give it this, bring on record, this is the claim, this is the clause.
There is a clause, my lord. This clause is part of the contract agreement. Contract has come to an end. This clause has gone. Arbitration clause is only survived in view of the section 16 of the Arbitration Act. And so many judgments are also there. Now,
No,
your lordship,
this contract agreement, the contract work has been executed.
yes, executed, performed, completion certificate issue, contract came to an end. Nothing survived. This is part of the contract. 16.2 and 16.3 is a part of the
Right,
contract.
right,
which has
right,
gone.
right. Will not be entitled to answer.
And statutory,
But for the dispute to be arbitrable, my lord, there is a contract clause which finds that the quantum of claim
this is
cannot.
provided, my lord, under section 16. Existence, non-existence of the arbitration clause will be adjudicated by the arbitrator.
So it will be applicable only.
And your lordship, section 6A is still available. And the constitution bench, your lordship, may kindly see, the constitution bench says, true intention behind this insertion of section 11(6)A in the act was to confine the court acting under a section 11 to examine and ascertain about the existence of arbitration agreement. There is no dispute, there is a arbitration agreement is in existence. On the merit of the admissibility, and my claim is within the limitation. Every claim is within the limitation of 20%. And one claim is relating to the breach of contract, which is not arising out of the contract, but under the law I am entitled. There cannot be any estoppel against the statute.
Now, Mr. Gupta, page 81. (16.2), it is clear. What is 16.3?
16.3 is that it is in two parts, my lord. One states that the contractor shall not ask for the reference for arbitration before the completion of the contract assigned to him.
That has been done.
That has been done.
Now,
The
second part.
my lord, says the contract shall seek reference to arbitration to settle dispute only once within the ambit of 16.2 above. The meaning of ambit is, my lord, the restriction of 20% would be applicable, the quantum of claim. That is because, my lord, there are.
So that means civil suit.
Yes. If the claim is more than 20%, they have to go for civil. That is what has been adjudicated in the ATW. And all these aspects have been discussed.
And I will satisfy your lordship that ATW case which my learned brother is referring is for inquiry. Because vital judgment of the Honorable Supreme Court.
Okay, let him bring their stand by affidavit.
Yes.
Heard R. And Mr. H. Gupta has come for petition for all the
Lord, 1, 2, 3.
1 to 3. Yeah. And I have submitted that. You have received instructions?
Yes, sir.
Yes, received the instruction by the affidavit on behalf of the respondent number 1 and such concept filed in
within 2 weeks.
Within 2 weeks. Yes, that's has filed affidavit in reply He counted from the respondent failure. He that had
And my lord,
released
in
the
this,
case on.
in the, my lord, in the same party, there was a case where the claim exceeded 20%. The appointment was made. They approached the Honorable Supreme Court, and Honorable Supreme Court dismissed their case.
But they
And
have
that-
appointed.
No, I have not. And that is also prior to the insertion of section 16A, 11.6A, my lord. 11.6A does not permit for the going into the details of the merit of the case for existence or not existence. This is the prerogative of the arbitrator to decide. These issues can be raised before the arbitrator. So many judgments are there. I have brought all the judgments. And even the Honorable Supreme Court says if the arbitration clause is non-workable, then the court can make it workable.
Now, whether there is a arbitrable dispute or not,
yes,
if it is prima facie evident,
yes,
that is
then whether this maintainability of the arbitration petition can
Yes.
be decided or not.
Yes, my lord. Here, my lord, they are
It is
restricting.
prima facie evident
Yes,
that the contract value is 8 crore,
yes,
say 8 crore, 20% will be
Exceeding.
1.62.
yes,
Evidently, your claim is more than 1.6.
yes,
The clause 16.2 says if it goes beyond 20%,
yes.
then it is not arbitrable.
And yes, now your lordship may
Now,
kindly see.
on the basis of these clear-cut facts,
Yes,
whether we should
yes. And now, my lord, they are restricting the pecuniary jurisdiction of the arbitrator. Not the accepted matter is there in clause 63, which is not arbitrable, clearly mentioned. We are
no, we are not into 63. Or
yes, this is the arbitration clause. My learned Baradan has referred the clause which is not the arbitration clause, which is outside the arbitration clause.
no, what
part
is
of the
63?
contract.
no, it is part of the
Yes,
part of the
no, no, not part of the arbitration clause.
yes, it is part of the
81, your lordship may kindly come. Pecuniary
My lord,
jurisdiction,
page 78
this
is part-
arbitration, my lord, based on the model law of the
page 78,
international law.
Page 78,
78
settlement of dispute.
16.0. My lord, 16.0 it starts from
Yes.
16.1 says the arbitration and settlement shall be governed by clause 63 and 64 of the GCC, which are reproduced
Page
herein
78,
below.
my lord, it is there.
And
Page
then, my lord,
78.
it goes on. Then comes, my lord, 16.2 at page 81, my lord, 16.2, 3 and 4.
Page 78, clause number 63, my
There is already a dispute as regards this 64.3
No, my lord,
or
your lordship
something
may-
like that.
Yes,
No, that was a
That is a
mistake. That is
different-
different. That is different.
your lordship may kindly come to page 78, my lord. Clause 63 is incorporated, where
Yes,
non-arbitrable, yes,
non-arbitrable.
yes, matters finally determined by the railway, all the dispute, page, my lord, 78,
Yes,
clause number 63 in the bottom second clause, my lord. From the bottom, matters finally determined by the railway, all dispute. Now here all dispute is there, my lord. And differences of any kind whatsoever arising out of or in connection with the contract, whether during the progress of the work or after its completion, and whether before or after the determination of the contract, shall be referred by the contractor to the GM, and GM shall, within 120 days after receipt of the contractor representation, make and notify the decision on all matters referred to by the contractor in writing, provided that matters for which provision has been made in clause number so and so of general condition of contract or in any clause of the special condition of the contract shall be deemed as accepted matters not arbitrable. This is not their case.
Okay, this is not the- okay, this is 6.2.
okay,
The pecuniary jurisdiction
on.
is against the law of the land.
okay, let us have it.
Hit by
This is the
the
case on.
yes.
Sorry to interrupt.
Time out faster. Yes, what's your time? How much time? There is no representation on behalf of the petitioner. John Paul. Zideka. Johnny Paul. Has entered interference on behalf of the respondent number 1 and Ms. Zideka has paid for his time. Right. Counselor exhibit on behalf of 1. After.
May it please your lordship. My lord, this is matter relating to appointment arbitrator.
My lord, I am
Section 11(6) of the Arbitration Act, my lord. As per the office note dated, my lord, 8/4/2024, service upon respondent number 2 was complete. Now it appears that the respondent number 5, 6, 7 has also appeared. Now,
who has appeared? Who has appeared?
I am
Who has-
appearing for number 2.
You are
For respondent number 2, my lord.
2 and you are 5, 6, 7. What about 1 and 3?
One, my lord, is a partnership firm. We both are the partners here.
1 and
The petitioner and the respondent.
What 3? What
Oil
about
India,
3?
my lord. Oil India, my
What
lord.
about 3?
Yes.
That is not served.
That is not.
IOC.
Not served. We have to wait for what? 4. 3 and 4.
3 and 4. 3 and
Okay. R. Goswami for the petition. Sir?
N. Chaudhary for the
N.
respondent.
Chaudhary and counsel for the
Respondent number 2, my lord.
2. R. Das for the respondent number 5, 6 and 7. And what about 1 you have said?
He said that he is appearing for 1 and 2.
My
Respondent
lord, I may represent, my lord. We both are the partners in the firm. I may represent one.
1. In view of the 8,4,000 debit for the service code healthcare service.
Obliged.
Chief Justice.
May I please your lordship. Matter pertains to my lord appointment of arbitrator, my lord. The service is complete, I guess. I'm appearing for the respondent. Appearing for 3 weeks time to file a notification. Certain issue. I'm also requesting my friend for a copy because my copy is. I'll serve. I'll serve.
Yes, Mr. Hazari.
Yes.
Yes, Hazari. Right. Therefore, Mr. Hazari is the party of the petition.
Deeply. I'm deeply.
Lordship, this is a petition for appointment of arbitrator under 11(6). Earlier, there one arbitrator, Colonel Manoranjan Goswami, he passed away. Then next arbitrator was appointed by this honorable court, and that arbitrator could not able to deliver the judgment in 1 year and 1.5 years. Then the district court has given extension of time after 1 year, 6 months, 18 months, which is not in the law. They have granted extension of time to earlier arbitrator, second arbitrator. Then I have challenged this before this honorable court, and judgment is enclosed here where that judgment is turned down by this honorable court as page number 6, annexure A, by setting aside the judgment of the this honorable district judge for extending the time after 1 year and 6 months. which is not as per law because we have not given the consent to that. And now the fresh appointment of arbitrator for this application exists.
Yes.
Some instruction has been received, but let me find a response, Lordship, that will be proper for me.
You're from Guwahati?
No, I'm from Chandigarh, Lordship.
Chandigarh.
But I'm staying, my brother's staying Tezpur. Actually, I used to go there.
What will be your convenient time then?
That in June 25th, earlier case is fixed here for 25th June.
Okay, 25th.
Obliged.
Mr.
Ghanshyam Das
is
Dhima.
the petitioner in person and Mr. B. Chakraborty, Learned Training House, Learned Central Government House, for all the rest. Mr. Chakraborty has submitted that instruction has not submitted. Yes, that's great. And it's gone to file to obtain necessary instruction and complete the instruction file contract. Yeah.
So they can send all as Lordship online, they can send their objections to me. Lordship.
Also, petitioner in person maybe serve with a copy of such affidavit in the online for the purpose of petition. The petitioner in person has provided his email ID to Mr. Chakraborty. So it provided it. Get the email ID as agreed to by the parties. Both the sides is the case of
25th Lordship.
25th June.
Obliged, Lord.
Mr. We'll put it on 24th. 24th. Is it okay? 24th or 26th? 26. 26. Or 24? 24. File it, Mr. Chakraborty, since he is coming from Chandigarh. Yes, madam. Water is short. Epidemic. Instructions received or not? Received.
We have till the enter to the achiever. We have sent a letter for calculating the amount.
You are interested in money or affidavit? Money. Hard MS? Please to know Allah comes for the petition. And Mr.
Sharma.
Sharma. You are for whom?
I am appearing on behalf of respondent number 1 and 4.
Okay. And it comes appearing for RM Water Department for the respondent number 1 and 4. Also heard Mr. Ikemedi for the respondent number TNC. A border size 2. Mr. Sharma has submitted that by placing an
being number 7 dated 12th of the WR division has submitted that the district commissioner has been requested and the circle of Kogamu Revenue Circle have been requested to undertake a survey of the private land, wherein some portion of the extended embankment has fallen, and to prepare an estimate prepare the land acquisition estimate. So, yes, how much time? Yes, that's not for 6 time to place instruction as regards the land estimate. Place instruction up to the instruction as regards the planning is the fair. What is the fair? Yes, anything? Land acquired. Is it a, yeah, verified. You want realignment?
Yes, sir.
Very impossible task. Yes. Notice has been issued. Any instruction? Yes. Sometimes you realign. Yes. Lengthy instruction, what is the part of this instruction? Sum and substance.
Sum and substance is that I have also very
Possible.
hurriedly have gone through, but what I can make out is with regard to that land which falls under what division. So that has been described here. So from there they can make out whether that land fall under that.
You please give us sum and substance of the decision.
Yes. Very hurriedly.
Why should I read all this?
Very hurriedly I have to go through, but still then. Or else can we?
Yes, madam. NHA, you want her land or not? You want her land or not? This instruction. There is no state.
With regard to that, it is not specific, but only with regard to that area of land which has been acquired.
Can we visualize everything unless you give your response? I cannot visualize. I am not in the field.
Yes, yes.
You are the field official. Made a prayer for petitioner has made a prayer for real hand. You take your decision. Tell us. That's all. Possible, not possible.
Realignment is
For what reason not possible? No, that is easy to say. But for what reason it is not possible? Bring it on paper. I have seen many things on the realignment. Cremation ground, you have realigned. something you have realigned. Yes, Mr. Borua is witness to that. You used to realign. Yes.
When it was not done by.
It is not that you have not made exception. But no, your response should be there. That is what I am asking.
It is not done.
I am not asking you to realign or align. I am asking for your response. Please place your response. That is all. And show us the reason why realign is possible or not possible. Only that much. We cannot substitute the views of the experts. You are there. How? Oh, you are NHIDCL. I thought that no forest is available. Okay, you are NHIDCL. Okay. Okay. Hard MS? A Bora. Learned counsel for the petitioners. A Bora says revenue and disaster. 1. S. Borua, Junior Government, Assam for the phone number 2, 3, and 4. MS Bora, you are for NHAI, Government of India. And Mr. Gogoi, you are for 6. Okay, MS R. Bora, learned training council for the NHAI for the response of 5. And Mr. D. Gogoi, learned training council NHIDCL for the response of 6. The learned council for the respondents have fought for and are granted 4 weeks time to file their respective counter affidavit. This is the case. 4 weeks. Oh.
But absolutely.
Why this is going on?
Sorry, set of but here my instruction is that they have not, but they have informed that they have already sent. But what I have proposed,
Why don't you convene a joint meeting and trace out all these things, Mr. This is writing letters for 4-5 years is too much.
But I have in email also they can give. I have handed over my email. In my email also they can forward.
Yes, Mr. Borbujari.
Pick it up.
If you have 10 queries,
No, but the role of
why don't you make a consolidated form? Once it is given, one query. Then next time it is received, another query.
No, but the role of finance has not yet come. But the proposal has to come from the CGM code.
Why don't you trace out everything? Why don't you convene a joint meeting and trace out these things? 7 years have gone by after his retirement. There is a direction to create a supernumerary post. Then that we have modified the interim order. It is going on this business.
But I have given my email address also. But the proposal.
You take a call, all three. You take a call. How to trace out? There is nothing since no appeal has been preferred. So it has attained finality.
In fact, from the judicial.
Because there, my lord, we are concerned with both of copies in Goalpara district, my lord. Now, my lord, at one point of time, way back in the year 1998, of the strength of the proposal of the judicial department, the finance department has, my lord, given concurrence for creation of copies, my lord, in all the courts in the entire state of Assam. Thereby, my lord, for the district of Goalpara, 3 sanction posts were, my lord, chairman. Now, how thereafter, my lord, the 3 posts were chairman and, my lord, persons were appointed. There is a case, my lord, where this person was not appointed, my lord, against those concurred books. That is the difficulty. Nonetheless, since there is an interim order for creation of the supernumerary post, once the proposal reaches the finance department, we will take a call.
No, it is not an interim order. Once the thing has been attained finally, is it not? What is it?
From our side.
I am not calm expert. Something has been directed. something has been directed earlier,
Yes.
right?
Yes. But
And thereafter, you preferred an interlocutory
yes,
application.
there is a direction dated 19/9/2022.
19/9/2020.
19/9/2022. There, my lord,
This is not interim. Nalage.
No, I
thereafter we have preferred an IA for modification of this order.
that has been modified.
That has been modified, and my lord, we prayed that instead of the direction for retrospective creation of posts, Lordship may allow us for creation of supernumerary posts with respect. That Lordship has my lord is taking up the IA.
Page 37 of the writ petition. The judicial department has already held that he is holding the post of office, then why should he not be deprived? Why he should be deprived? So it has attained finality so far as this decision is concerned.
We are
His legitimacy. Legitimacy. Now how this is to be, the benefit should be extended to them.
Lord.
That is the only question.
Yes, my lord, the
Creation of post or supernumerary. And that has been modified.
that has been modified. Lordship has allowed us for
Hmm.
creation. My lord, we said that the proposal has to come from the court where he served. They said
How to expedite the process? I am concerned with that only. We are not. How to do it? You suggest.
my lord,
Mr. Borpuzari, please
my lord,
suggest.
I have requested
Mr. Das, please suggest.
I have requested my friend, my lord.
He has retired 7 years back. I think. Then I will ask Mr. Nath and Mr. Borpuzari to convene a joint meeting of the finance department and their office and trace out. These writing letters in June, Nath will be writing. In July, Borpuzari will be responding. And again, September, Nath will be writing. After 2 months, Borpuzari will be responding. Please provide this. No, nothing is imputed. Nothing is imputed.
Now, this is the proposal. But you can kindly, but here we have
Let him, as per his prayer, let him.
that the proposal comes from the same department, but it will be made by the same department to the finance department.
That is because there is nothing disputed.
Yes.
We decide, right?
Correct.
Third, the AI Util and Kausapata petitioner, Dinath, and Senior Government Advocate Assam, for the first. P. Chakraborty is there. P. Chakraborty. P. It get us. Sending out the report. For Pujari,
Yes.
Uh,
It's for R2.
art. Dinat is for
One.
one. As requested by Mr. Verma and sending of AC, this is the case on Friday. Who has placed it?
Commerce.
The impact is by Mr. Das. Hearing number 7 dated 4/4/2000 is kept. My only interest is early expedition disposal.
What is our pleasure?
At this stage, finance.
Okay. Friday, Mr. Das.
Yes, the moment the moment we definitely. But I'm just setting my instructions so that Lordship may keep it.
Same thing. As placed by Mr. Das.
No, they say that they have already sent. We are saying that we have not. That is the problem.
No, I have not adverted to anything. That will be adverted to on Friday. I have kept it on record on. I have just recorded that as requested by Mr. Das. Friday will deliver it. Bring some PP. Then take up. Yeah. Why it has come?
Lordship, aiming for is the benefit Lordship sustaining
EOA finance. Yes. Society, Orwa, finance.
We are writing letters regarding the letters that I don't give.
Writing letter.
We are hopeful of getting some instructions for the department
Hopeful. Revenue.
because the vehicle is identified. Therefore,
Rajio scheme says so.
so but the interpretation of the law as the Honorable Supreme Court has laid down. Because ultimately, if he succeeds in the MSC claim,
No.
the anesthesia will be deducted.
Discuss about any anesthesia.
Yes.
Anesthesia.
Yes.
Anesthesia formulated by who?
By our department.
The Supreme Court has discussed anesthesia formulated by your department.
No. In that case, matter, in that particular case, there is a scheme for compassionate.
By the employer.
Yes.
By the employer, is it not?
Yes. But
and there is a difference between an employer and the state as a whole.
Fine.
But whether you are expecting really.
So we have written to the department very recently. So we are expecting something from them. But kindly grant us some time.
Beyond June, no. Beyond June,
we will try.
Because otherwise, numbers are being added every day. You have the option of bringing clarification also, which you have not done till date.
The recent that recent notification excludes everything except written ranking. So that we have.
Mr. M. Soikia and Council for the as Borwa. 1, 4, 5, 6, A water side, and extending up revenue and industrial arbor. Southern Council. short form and write down for to file their response.
That's all right. That's 2014 notification minor that has now been amended. And so far as grant of SCC of 2 lakh to person concerned, the state grant has been made. All other
When?
The latest notification. 23.
Very to us.
Yes. Bring it.
on record by filing.
Lordship, our claim, Lordship, on 15/11/2014, Lordship. Sir, that Lordship notification.
Let us will say prospective or retrospective.
Yes, retrospective.
It is not statutory rules.
Yes. Obliged.
Make this. So otherwise, your lordship may close this matter because your lordship, if your lordship kindly takes up annexure 3 of the contempt petition, your lordship.
Annexure 3.
Yes, your lordship. Page number 18, your lordship.
18.
In this particular order, there is an interim order which has been passed by this honorable court, your lordship. And pursuant to that order, your lordship.
18. Okay, 18.
Yes, sir. So lordship kindly takes page 19.
Cannot take any court effect.
Lordship. Then the respondent.
This is dissolution.
Yes, your lordship. Now the
COVID.
Okay. Now your lordship, if your lordship kindly takes up annexure 4, page 46, your lordship. This is the order which has been passed by the contemporary during the pendency of the interim order, your lordship. That is order dated 18/3/2023. Now your lordship, challenging this particular order 18/3/2023, they have preferred another writ petition, that is WPC 1851/2023, that has been disposed of by this honorable. Your lordship kindly takes up paragraph number 2, your lordship, of that. Paragraph number 2 of the order dated 19/6/23, passed in 1851.
What is the ultimate order?
That is the impugn order is 18/3/2023. That is the order which has been challenged in the contempt petition also. And in fact, your lordship, the name of the
benefit was granted to the petitioner.
And
now
the last
why they are
occasion
not
also
here?
they have not, no one appeared for the petition.
Okay, we'll record that and we'll make it also. There is no representation on behalf of the contempt petition. Today on call. Mr. D. Bordoy Lanet, for the response number 3 and 4, has submitted that the contempt petition is preferred, alleging violation of an order dated 19/2020 and other order passed in WPC number 16/2020. The WPC is disposed of or not?
Yes, sir.
Huh?
Disposed.
When? 1622.
I'll have to check.
It is submitted by him that one order was passed by the Adequate Register of Cooperative Society on 18/5/2023, whereby exercising power under Section 41 of the Assam Cooperative Society, comma, officer, one departmental officer was appointed to manage the affairs of the society and hold again to protect within 90 days from the date of issue of the state order. The state order dated 18/2023 was delayed in the number 1851/2020. The state petition was closed by an order dated 19/6/2020, granting the relief that the erstwhile members of the board of directors would not suffer disqualification as provided under Section 40, within bracket 4, within bracket small and small, and Section 41, within bracket 4 of the Assam Cooperative Society, and they would be entitled to participate in the ensuing election of the board of directors. Mr. Bordure has submitted that the petitioner has got the relief in the meantime to pursue the contempt petition. That has to me in view of not behalf of the on-call command. It is our on
Your Lordship, this contempt has become infractor. The subsequent order passing the writ petition, Your Lordship.
It has been recorded already, but because you were absent.
Yes, on the last occasion I was
Yes,
absent.
we have already recorded. Heard Mr. R. Mojumdar, learned counsel for the petition, and Mr. P. Nayak, learned counsel for the response number 2. Also heard, you were there. MS K. Phukan, learned counsel for the response number 1. Full stop. The contempt petition is preferred, alleging violation of an interim order dated 25/8/2023, passed in a writ petition, WBC number 4700/2023. Subsequently, by an order dated 24/11/2023, passed in an interlocutory application, IS civil number 3442/2023, the interim order dated 25/8/2023 has already been vacated. In view of such situation, the learned counsel for the parties have submitted that the contempt petition has become infractor. It is according observed that since the contempt has become infractor, the contempt is then closed as infractor.
Lord, in this contempt petition, I am appearing on behalf of LS contempt number 2. That is, my lord, Chantush Mahan Yadav, it is chairman of National Highway Authority. And I have filed an affidavit of an opposition here because that particular road is not being constructed by National Highway Authority of India. That is our stand in affidavit. It is wrongly implemented in writ petition.
Anyhow, in a wrong, it would have been our duty when I was defending the case that the repetition also how it been disposed of.
What is the order alleged to be?
Alleged to be what happened, my lord? That
Paragraph, page. What is violated?
So page number 57.
67.
The original status quo was is dated 12/3/24, page number 63, and subsequently again in
This
page
number claims to be a lessee. Moses Furnish. Then to
here
the expert for
here.
So status quo was done.
Granted.
Then-
Fact was delivered.
Then thereafter,
Thereafter, this case has been again it was in motion.
15-3.
15th it was passed.
Interim order was passed.
Passed.
Then this petition is filed alleging what?
Alleging
That
there is a
construction
violation of order dated 12/3 and 15/3, whereby according to them, this status quo is order is violated.
Okay. Now, amongst the
Violated.
respondent arrayed
Uh,
in this contempt petition,
Yes.
you are appearing for whom?
Alleged contempt number 2, that is Chairman National Highway, that is by name it is given.
Okay. Chairman National Highway.
Highway
Authority
Authority.
of India.
I filed the affidavit stating that because that particular road is not constructed by us, and because no land is required, that is why our name would have been wrongly implicated in that. And the order which was disposed of on 3rd 4 or 12/3/15/3 is our also, we have also not neither mentioned nothing, it would have been not come. Otherwise, our name would have been not there. Anyhow, my lord, first one is first. Because as my road is not constructed by me, but putting me by a violating order, another question doesn't arise.
Yes, Your Lordship would like to file a in reply because towards the entire petition that has been now disposed of, respondent number 2 has appeared, Your Lordship.
Yes, that is correct.
And
That
they
is one point is
IA
there.
also for vacation, they filed affidavit opposition also. Now they are taking the stand there wrongly.
No, he is correct. In this point, he is correct, my lord. That I have to agree on that.
Let him respond.
Let him. But he is in this point correct. It was our bond ended because it is a contempt. It would have been, but it would have not either submitted or wrongly it has been heard.
Oh, that I was filed for vacating the order on what ground?
Not vacating. I am filing a affidavit of position. Affidavit of position to this contempt petition, my lord.
No.
Earlier.
In the writ petition.
Writ petition, I did not file.
I was filed.
Union of India did not file.
That is Union of India, not NHA. For vacating.
But one thing is there, my lord.
Opposition was also filed.
But one thing is the writ petition has already been disposed of on 3rd 4. It is already writ petition gone. Only this is that was earlier order of writ petition.
What is the final order? What is the final order?
Final order, the repetition was disposed of, directing us to file a appeal before the ADC, Your Lordship, because we had agreed that the ADC was not hearing our objection, Your Lordship, and then we are directed to appear before them, and ADC was given a timeline to dispose of the our objection hearing, Your Lordship.
So, for what purpose you are pursuing this contempt petition?
So, Your Lordship, that the contempt was issued prior to the final order, Your Lordship.
No.
In between,
Still, I am asking.
the violation had actually taken place, Your Lordship, and we had annexed the photos which clearly shows that, especially respondent number 9, Your Lordship, the Anil Das, the contractor, J Das.
J Das, I can't for the petition. Who is for one? Who is for one? Party's name. Who represent whom? Okay. Who is for two?
Two I am appearing.
T. Borua. Learned counsel for the respondent number. Who is for three? Anybody has appeared?
Additional Chief Secretary, Sundar P. Gupta.
Right. Okay. Mr. Borpujar, R. Borpujar, Learned Counsel of State and he has entered appearance on behalf of the respondent number 4, 5, and 6. Okay. 4, 5, 6, 7, and 8. By filing, you are appearing for number 9. Okay. Game. Comfort of he has entered appearance on behalf of number 9.
I filed affidavit. Appeared in file.
4, 5. An affidavit of which has been filed on behalf of the respondent number entirely of the pair to strike off his name from the area of response. Mr. Das is granted 2 weeks time to fight a affidavit of which, sorry, a reply affidavit in view of the office dated 8/5/2020, await for the report of service. Report as legal service of state number. Please check it out.
But Lordship, here, Lordship, he'll need some accommodation to file a affidavit.
Service is complete. Yes, sir. Service is complete. Yes. You are for petitioner. Who is for 1, 2, 3, 4, 5, 5.
Lordship 5. Lordship.
And 8 also.
Yeah, yes, Lordship 8 also.
You are for 6 and 7. And who is 6?
Director of Health Service. Lordship for 6 also, I can.
Heard, Mr.
N. Brahman.
M.
N. Brahmo.
N. Brahmo. Learned Counsel for the petition. Mr. H. Chodia, Learned Standing Counsel, Health and Payment Welfare Department for the response number 1, 6, and 8. And Mr. H. R. Das, Learned Counsel for the response number 7. So, as the service is complete upon all the response. Both Mr. Koliha and Mr. Das have prayed for our granted. Please thank by their respective conference.
May I please, Lordship, matter may pass over for a day. Engaged counsel N.S. Thakuria have left the court. Please speaking by
N.S.
Thakuria.
Your name, please.
Service is not complete.
Your name.
D. Angana.
D?
My name is not in the cause list.
Okay. Your name.
D. Angana.
D. Angana. Learned Counsel appearing for MS. NS. Learned Counsel for the petition. Mr. Bora, you appear for whom?
I appear for the PTC authority, mother.
Hmm?
PTC. Response number 2, 3, and 5.
Mr. Any transport? Mr. R.B. Gusam. Learned Counsel representing MS MD Bora, Learned Standing Counsel, Transport Department for response number 1 by and Mr. S. Pora, Standing Council BTC.
2, 3, and
For the response number 2, 3,
and 5.
4. Finance
4.
Secretary BTC.
Yes, finance.
4 and 5. The as per order dated 26/4/2024, of the Lodima, the service of notice. Sorry, the service of notice is complete in respect of the response number 7. You are directed to obtain instruction regarding proper, present, complete address of response number 6, 7, and 8. As per the state order dated 26/4/2024, the petition has been directed to obtain instructions regarding the proper, present, and complete addresses of response number 6, 8, and 9. MS Council for the has paid for testing of the structure in order to obtain such address. Please take.
Okay.
Right, please. Number 1 is the main contesting respondent. An
What is it?
arbitration petition.
IA, what is IA?
IA was arose because on 15/3 when another bench took up the matter, notice was issued, but that bench was of the view that for stay of the proceeding, a separate IA would be necessary. So I have filed the separate IA of the arbitration.
Why?
Because this arbitrator is unilaterally appointed by the other side, by the respondent number 1, and there is no consent from my side. And after the so many judgments of the Supreme Court recently, including in Eastman, Perkins, and other judgments, there cannot be unilateral appointment apart from there being consent by the other side. There has to be appointed with the consent of both parties or by.
Yes. We are supposed to file an affidavit. I still to receive certain documents. We file an affidavit. And Lordship may take up the matter for final scope.
Steps were taken on 2 and 3 also. 3 is the arbitrator.
He is the arbitrator.
Yes, he is the sole arbitrator.
So in an arbitration proceeding, is there provision for stay?
Look, in this case, this appointment is completely contradictory to the judgments of the Supreme Court, which have held that such unilateral appointment by one party is rejected. Lordships are aware that. For
No, I'm
example,
just
yes,
question. My
for-
question, in an arbitration petition,
Lordship.
the court has said that
Separate petition, yes.
But where is the provision? Is there any provision?
Since section 11(6) being otherwise a judicial power, it has to be held inherent to that. It's not an administrative power. That was my submission before the other bench also. But
is there any offer?
Directly, no. But if the arbitration is allowed to proceed and reach a conclusion, then there will be an ex parte award, and again there will be a multiplicity of proceeding. Because the appointment itself is illegal.
Is there anything, any authority on that?
On what?
You
the,
say inherent everywhere, but under what circumstances?
yes, my lord,
This
circumstances.
is
my
my
lord,
simple query. I am not conversant with the arbitration law.
No, no.
I am asking for the assistance of the council.
my lord, the appointment that is challenged is contrary to the law settled by the apex court.
Right. So whether this question can be raised before the arbitrator or not.
No, this arbitration proceeding itself is illegal. When the appointment is illegal, my lord, then everything has to be set aside. I am asking for a substitute arbitrator.
Think it over.
Because I shall satisfy. Let the matter come
Think
up
it
for
over also. Go
disposal.
through the provisions also.
Lordship.
Then you say, go through the entire arbitration act.
I understand
Don't
the-
read only
Yes, I
11 and 12.
Lordship. In fact, my prayer was more under 15, my lord, for substitution of an arbitrator. For that, my lord, this proceeding has to be. I am asking for an appointment by the court.
Okay, how much time you need? 2 weeks. If the appointment is illegal, order will be illegal. Hard.
Yeah.
A. Ganguly, learned counsel for the petition, and Mr. Didas, learned counsel for the response for one. That's great. And it's granted 2 weeks time. File. Affidavit of opposition. So this after
Can a date be fixed? First week June.
2 weeks. So otherwise, service is complete or what?
Sir,
Why
one
it has
week-
come in the order column? Because of IA or what?
Yes, the IA, no, the service. on
Anything
the
more?
last day-
How many respondents?
3 months.
It is because of that part. Because of respondent number 2 and 3.
Because on 3, I can take Dasti. And as far as 2 is concerned, she is my own sister. On 3, I can take Dasti. 2 is in Delhi, my lord.
Okay, notice has been issued. Okay, in view of the office note, await for the report as regards service of notice upon respondent number 2 and 3. Mr. Ganguly and Council has submitted that he may be permitted to take steps for service of notice upon the respondent number 3 by way of the state. The prayer is out. Compliance affidavit negative. Rooted to the registry negative. Then it will be
So I may be sub to the copy of the IA notes.
So Lordship, in this case, petitioners are owners for land measuring 9 bigger 17 lesser covered by tag number.
The service is complete.
Lordship, I am appearing for response number 9, 12. They filed
Who are represented?
response number 12.
Union of India and Bora. NHAI. NHAI is here. Get 1, 2, 4. And motorcycle 5. 5, 6, 7, 8. Mr. Which for 5, 6, 7, 8. As Purva is for 9, 10. And Puya is for 12. Okay, complete. That's all. That is the purpose.
Yes, sir. And also
Hard, Mr.
we have also filed a additional affidavit your Lord. But it has
File
not been
it, it has come for orders only to check. Hard, Mr. Data.
Yes, sir.
Not a computer. So, as the respondent number 1, 2, 3, and 4 are represented by Arbora and NHI, NHAI, and NHI. The respondent number 5, 6, 7, and 8 are represented by the 9, 10, and 11 are represented by Mr. Elwood and the respondent number 12 is represented by Mr. KP and the service of all that.
So Lordship, an interim order is there.
complete. So, please like after it and follow. The interim order pass the respondents may file their respective counter affidavits in the meeting. Yes.
I have taken step dusty service upon 3 and 4. 1 and 6 can be step, and respondent number 5 has been already been stuck off. So service can be default.
Who is this one? One is urban development. Who represents urban development? Two is municipal board. Three is municipal board. Four is also. Five. 2 to 5. Who represents?
Matlab, 5 has been stuck off. And
been
3 and
stuck
4,
off.
my lord, I have taken dusty
Notice has
service.
to go with it.
3, 4, my lord, dusty service has been taken. The affidavit is on record.
As Borua on the previous date, 1, 5, and 6 are represented by you or N Gustami.
N Gustami.
So you can represent 1, 5, and 6.
5 has been stuck off.
5 has been struck off.
Last
Yes,
out.
1 and 6 we have here. Executive officer.
Your name?
HK Sharma.
It's just what up. From the affidavit filed by the petition. My transfer notice by has been served after on 34,000 as managed for the response of the data get
Well, there is an interim order. Much.
I had taken steps upon the respondents, Your Lordship. The mutation of my land was cancelled, Your Lordship. An interim protection was provided to me by the order dated 26/4/2024.
6 to 9. Step.
Yes, taken steps.
What happened? You have taken steps. Wait then.
Yes.
4, 5 only it has gone. Delivery, paper size, revenue, 1. 86. As 4,
4, 5.
4 and 5.
Circle of it. Oh, BTCP.
Four.
Unit 4.
Four. In view of the official date, 9/5/2000. I wait for the report as regards service of notice of the responsible. Is that after 2 weeks for service report, the interim order past reversal. Yes, Mr. Bora.
May please. The FR is at page, we are
Wait, it has
forwarding at
come
page
to the-
17.
it has been dismissed earlier by me.
Yes, my lord.
It has been dismissed by me earlier, or what?
No, I know, my lord.
Huh?
To my inspection is the first time we are.
Why?
So, my lord, I am also informed that what matter is this.
Before
The notice is issued by your lord.
for that only.
No, no,
No, is it a case that I have rejected the brain prayer? No.
no. To my inspection.
Otherwise, yes, I know that if the bail is already rejected by me,
Yes.
it should be listed.
Yes.
Yes, Mr. Bothagur.
But regarding that, my lord, right now I have no information regarding earlier rejection or if my lord any other request for. Oh,
Is
lordship,
there any
yes, yes. One there is a one bail application was taken by your lordship of a co-accused in the same affair. Maybe. But
that is the reason?
maybe.
Okay.
Yes, my lord, from the case diary, my lord, total, my lord, 50 some 7 numbers of my lord e-rickshaw battery, my lord, and 160 numbers of chargers and many other articles, my lord. Total value, my lord, is more than from the FIR book, my lord, more than 56 lakh.
56 lakh.
Yes. And
Page
now,
16, 7,52,000.
yes, but page 17 is my forwarding.
No, page 16, second line.
Yes.
507 number of e-batteries
Yes.
and 168 chargers.
Yes.
And value was rupees 7,52,000.
Yes, yes. Then, my lord, that may be
472.
Yes, 7,52,472. Yes.
Who is the other order? When you were arrested?
I was arrested on 25/4. 19.
Yes. What is the ground for keeping him?
Because all the articles not yet recovered, many are on the basis of initially, my lord, police arrested, my lord.
In a course of investigation from his relative house.
Yes.
That is the only ground.
Initially, my lord, arrested one, Mujahid one, thereafter,
And myself, the Boda, and you are likely to be arrested. Suppose your relative's house stolen items are from. Any other ground?
My lord, only because of that, all other articles not yet recovered, my lord, on the basis of the.
But specific to him, there is nothing. Relative house.
Initially, my lord, some
It
photographs
will be
were.
too far-fetched. Everybody is likely to be arrested there. It's not that. What kind of relative? How many degrees? Maybe first degree, or 7 degree also. In Assamese, elek or pelek, then only also he will be brought in. Hard, it's TP Bora. Then a council photo accused. TP Bora.
P Bora.
P Bora. Learn a traditional pub. In the course of investigation, a number of persons had stroke have been arrested. As part of following dated 25/4/2020, comma 29. Or paragraph 4. As per the accused petitioner has been apprehended and forwarded to the court of Karnataka Kamrup Metro on 25/4/2000, and since then, as per the forwarding report dated 25/4/2021, 10 number of stolen e-rickshaw battery and 10 number of e-rickshaw chargers were recovered from the house of a relative of the accused petitioner. An apprehension, it is mentioned that there is apprehension that the crime has been perpetrated by an organized group.
Yes.
Where Mr. Pothakur and has submitted the materials the biggest suspect of in the crime as number of items have been recovered from the house of the accused petitioner. It is further submitted by him that substantial part of the potential have not yet been recovered. The accused petitioner is in custody in for how many days?
19 days.
Huh?
19 days.
19 days. 55, 24. The main ground for apprehending the in number of e-rickshaw battery and 10 number of e-rickshaw charges have been recovered from the house. Whereas the illegal in the affair is that 507 number of e-rickshaw battery and 108 number of e-rickshaw charges have been for rupees 7 lakh have been put. Having regard to the fact that for the period of 90 days, right, and considering the fact that most of the time is recovered from the custody of command, 3,000 monthly.
On the basis of his statement to the on the residence of his father-in-law, his father-in-law.
Father-in-law. I have gone by this forwarding report.
Yes. 41A notice was also not given prior to it.
Hmm?
And 41A notice also was not given prior to it.